PF ಯಾವುದು serial number? PF first time
Submission, one memo.
Yes.
Malaysia for first matter, Malaysia for notice.
Why
No
you are
audio.
moving?
No audio, please.
What is the urgency?
Notice.
Yes.
Return of LCR.
Huh? Huh?
Return of LCR, trial court records, amount deposited by the
Yes,
insurance.
Amount for amount release.
yes.
Company appeal.
Amount,
What is the urgency?
amount was
Stay, my lord.
Yes,
withdrawal of the amount.
Withdrawal of the amount
yes.
and treatment must.
Well, as one fresh matter, let
Two
company
max.
appeal, the claimants are filed execution and
Yes,
seeking
yes.
tomorrow. Public.
My lord, serial number 43, my lord.
1
Council
minute.
seeks for
1 minute.
My lordship, serial number 35, my lordship, I am for appellant, my lordship, kindly refer to Lok Adalat, my lordship. I informed other side also, my lordship.
Your good name, Mama.
Akshaya.
Miss Akshaya, representing Sri Pavana Chandra Shetty H, Land Council on record for the appellant, seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat.
36, my lord.
Pledge, my lord.
Yes,
36.
36, yes.
This may also be referred to Lok Adalat, my lord. I will file wakalat in the Lok Adalat only. Okay. Only on quantum. I have to file wakalat. I have
You
received
have
the
not
copy.
filed, you have not filed your wakalat, Mr. Council.
Yes, my lord. A week's time may be given. I will file wakalat also.
You file wakalat, thereafter we'll see. Next.
My lords, serial number 61, my lords.
Kindly have it
minute,
next
Mr.
week, my lord.
Council.
Kindly have it next week. I will file wakalat, my lord.
Yes, yes.
Yes,
Let us,
much-
yes.
Much.
My lord, serial number 61.
1
Sir,
minute,
batch of-
Mr. Council. 1
My lords,
minute,
batch
Mr.
of,
1 minute, Mr. Council.
sorry, my
Committee,
lords.
sir.
Sorry.
Page wise. Page 8, 38 to 42. Page 9, 43 to 48.
Serial number 43, my lord.
Yes,
Council seeks for time, my lord. My senior is unable to attend due to personal inconvenience.
you are representing whom, Mama?
Appellant.
We'll see when the matter is called. This is
Serial number
2020.
48, my lord.
48, yes.
Appellate counsel is suffering from dengue fever, my lord. Yes, not
Yes, your good name, Mr. Council.
Kalimullah Sharif.
Sri Kalimullah Sheikh, representing Sri Sunil KN, Land Council on record for the appellant submits that Sri Sunil KN is suffering from dengue fever. Full stop. 6 time.
Inter matter to be continued.
Serial number 46, my lord.
Well, inter matter is there, my lord.
Hence, list on. Today is what date? Hence, list on. 22nd October.
Act-
Interim order granted earlier is extended to the next day.
Serial number 46.
From the other sides.
Yes, 44,
46, my lord. Refer to Lok Adalat.
40,
6, my lord. 46, my lord.
Satisha T.
Refer to Lok Adalat.
Sri Satisha T. Land Council for the appellant seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
Page 10, 49 to 51. Page 11, 52 to 56.
Your lordship, I represent B.S. Padmaja in serial number 54, your lordship. She seeks an adjournment since she is out of Bangalore for the day.
May I know who is representing?
I am R. Govindarajan, advocate representing your lordship.
Sri R. Govindarajan appears through video conference representing Srimati Padmaja B.S. Land Council on record for respondent number 2. Full stop. Have you informed the other side, Mr. Council?
No, your lordship, just now she has to urgently
Next.
report to go
Pages.
to Mysore on a medical
We'll see
emergency.
when the matter is called, Mr. Council. Without informing the other side, please don't represent. Next.
Page 12, 57 to 60.
57,
Your lordship, 57, I filed memo for withdraw the above.
Yes, sir.
Withdrawal of
Withdraw.
Feel.
Out.
I am for respondent in this.
serial number.
57.
B. Maheshwarappa.
Serial number 57 is MFA 5890 of 2023.
Please, my 23.
5890 of 2023.
5860. Allah.
5890.
Sorry.
Next, you filed memo when the matter is called, Mr.
Aye.
Next,
Serial number 58, madam.
58, yes.
Refer to local.
At request of C.
Hello,
Satisha T. Land Council for the appellant, comma, the matter is referred to Lok Adalat for settlement.
Page 13, 61.
My lords, I appear for the respondent number 1, my lords. I have not filed wakalat yet because I have not got any instructions. And these MFAs are filed by the victims. And 61.8 and 61.9. It is two appeals are pertaining to my petition, my lords. My lords, a date may be accommodated so that I can ask the instructions of my client and I can
These
file the wakalat.
matters are of the year 2021, Mr. Counsel. How much time can we grant for filing wakalat?
My lords, 2022,
Let
my
us see
lords.
when the matter is called. Let us see. Let us see when the matters are called. Yes.
Page 15, 62 to 66.
Serial number 63, I have informed, I am for the petitioner, I have informed the other side. I need 1 week of adjournment for
Fine.
translation, I need to file in translation.
Huh?
Translation, senior,
You want to file it?
translation. Copy. Translation. There is
Translated copy of Kannada documents.
Your good name, Mr. Counsel.
Uday.
Sri Uday representing Sri Raju, yes, for appellant. Seeks time to file translated copies of the documents over which the appellant relies upon. Stop time for 2 weeks is granted. List on 22nd October.
64, my lordship. The TCR is maybe required because we have questioning liability, my lordship. Other side, I have informed them.
Yes,
PCR.
PCR is available.
Serial number 66, ma'am. PCR may be called. Case of liability, ma'am. 66.
66 also.
Also received. ಬಂದಿದೆ.
My lord, serial number 70, my lord.
1 minute.
Page 16, 67 to 70.
Serial number
Rangi
70,
Koda
my lord.
NR, Land Counsel for the appellant seeks to refer the matter to Lok Adalat for settlement. Hence, the matter is referred to Lok Adalat. Yes, Mr. Vijay Kumar?
Please, my lord. In this case, my lord, I have not received the copy of the appeal memo. My lord, I have been directed to take notice only on 6/8/2024 recently. I'll collect the copy and file my wakalat and then it can be disposed.
Sri D. Vijay Kumar seeks time to file wakalat for R2. Full stop. Also,
Kindly direct the other side to
reports from
furnish the
the
copy.
concerned tribunal are not yet received. Received. Land Counsel states that he has not received copies of appeal papers from the appellants. Full stop. Appellants to serve copies of appeal papers immediately. List on 22nd October.
Much obliged.
Serial number 68, ma'am. Awaiting TCR.
ಬಂದಿದೆ.
TCR to be
Received.
received, please.
Serial number 1 for orders, NR Rangegowda.
Filing memo for dispensation of
For
notice to respondent number 2.
Why it should be dispensed with?
The liability fixed against the first respondent.
Heard. Sri Rangegowda NR Land Counsel for the appellants. Land Counsel files memo seeking dispensation of notice upon respondent number 2. Full stop. Land Counsel states that as liability is fixed upon respondent number 1, notice to respondent number 2 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 2 stands dispensed with, however, at the risk of the appellants.
Please. Next week.
Admit.
I am for respondent 1 on behalf of C. Lakshminarayan I am representing. Behalf of C. Lakshminarayan I am representing, my lord.
3. Lakshminarayan C. Land Counsel on record for respondent number 1. Will stop. List the matter under the caption final hearing on 17th September.
Much obliged.
Much obliged.
Serial number 2, Shweta Anand. Serial number 2,
No representation on appellant side on call. Stop. As per office endorsement, the appellants have not deposited, have not filed proof of depositing %50 of the award amount as ordered by this court on 3/7/2023. Next pair. Also, as per office endorsement, copies for furnishing notice to respondent number 1 were not furnished. Full stop. There is no representation on appellant side at least. Full stop. In the light of the fact that the appellants have not represented to state as to why proof of depositing the award amount as ordered is not filed, and as to why copies were not furnished for sending notice to, the requisites were not furnished for sending notice to respondent number 1. This court orders that in case requisites are not furnished within a week and acknowledgement of having deposited the amount as ordered on 3/7/2023 were not furnished, the appellants would be at liability to deposit entire award amount along with the accrued interest before this court within a period of 1 week. Within a period of 1 week thereafter. List on 19th September.
Serial number 3, B Latif.
Filing a memo for dispensation of notice to R2.
R2 is no more.
In the next state, I'll file a dispensation for R1 also. Liabilities on insurance company.
R2 is no more, Mr. Counsel.
Please, my lordship. Then in the next state, steps.
Your good name?
Chirag, you.
Sri Chirag, representing Sri Latif B, Land Council on record for the appellant seeks time to take steps to bring the legal representatives of the deceased respondent number 2 on record. So, hence list on 22nd October.
Please.
Serial number 4, Latur Suresh. R37.
I'm for appellant in this case, madam. Memo filed, ma'am. R1 and R2 dispense, madam. Kindly dispense.
Why it should be dispensed? with them?
R1 and R2 ex parte before the tribunal, madam. R3 is liable, madam.
Heard. Miss, your good name was?
Smita.
Smita, Land Council who represents Sri Latur Suresh Mahalingappa, Land Council on record for the appellant. Full stop. Memo filed seeking dispensation of notice upon respondents 1 and 2 is on record. Full stop. Land Council Smita for appellant submits that respondents 1 and 2 remained ex parte before the tribunal and therefore notice to those respondents may be dispensed with. Full stop. Having considered the submission thus made, notice to respondents 1 and 2 is dispensed with, however, at the risk of the appellant. Sri B.C. Shivanagowda is called upon to accept notice for respondent number 3 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat to be filed within 2 weeks. appellant to serve copies of appeal papers at the chambers of Sri B.C. Shivanagowda. List on 29th October.
Madam.
Serial number 5, MV Maheshwarappa.
I appear for appellant. I
P.
filed memo
Pradeep.
with paper publication.
I am for
R1.
respondent number 2, my lord.
You have verified.
R1,
Publication
Sanjay
effected
Kumar Jain.
and the copy of the same is on record. Full stop. R1 called absent, no representation. Service held sufficient, recorded. Yes,
I filed memo for with paper publication. Your Lordship.
yes. we
I
have-
am ready.
Yes,
Now, your Lordship, I filed for enhancement and as well as the pay and recover against the insurance company. Insurance policy is valid. Case of injuries, your Lordship. A fracture of left proximal lateral tibia, candle type of 2, sciatica and underwent lateral batteries. The total award by tribunal, your Lordship, 1,68,794.
yes.
The tribunal award of pain and sufferings is on lower side, your Lordship.
What are the nature of injuries sustained?
The fracture of left proximal lateral tibia. Candle type 2 and underwent lateral buttress. Doctor examined, your Lordship, the Dr. Krishna Prasad. Total disability, your Lordship,
Where is the nature of injuries mentioned, Mr. Counsel?
in the
Judgment page number 14, my lord.
Fracture of left proximal lateral tibia condylar type 2.
exhibit P1 to P29. Now, your Lordship, towards the petitioner has contended that due to the accident, he has sustained injuries, underwent surgery and discharged with advice to take follow-up treatment. In order to prove injuries caused to him, he has produced wound certificate exhibit P11. Sustained injuries, the doctor has opined that the injuries are grievous in nature. The petitioner has produced discharge summary at exhibit.
One grievous injury,
Swami,
only one grievous injury.
only.
He's continuing same job, my lord.
And medical bill produced 55,594.
So on what ground you are seeking enhancement of compensation?
One is the enhancement of compensation, another one is
On
the
what ground you are seeking enhancement of compensation?
doctor evidence, your Lordship. As per the doctor evidence PW2, disability of limb is 39% to the whole body at 13%.
So PW1 in his cross-examination admitted that he was working in the same company and by the date of accident, he was drawing 35,000 and now he is drawing 49,000.
That is, your Lordship. The other head, your Lordship, is on lower side.
Yes,
Pain and sufferings, your Lordship, 50,000 paid. Medical bill 55,594. Food and nutrition, that is 3,200. And towards conveyance 10,000. Toward loss of income during treatment 20,000. Amenities is on lower side, your Lordship. The nature of fracture and treatment, your Lordship, is on lower side.
yes. What is your contention?
My lordship, they have not produced any leave certificate, my lord, before they have taken treatment period, they have absent in company. But loss of future earning does not come around because he is getting same salary, he is earning more than after accident also. Maybe other rates, my lordship, towards conveyance, loss of during income treatment period, my lordship, that may be increased, my lordship. Future amenities also has been given, my lordship. The deprivative of future amenities, 30,000 rupees has been awarded. Pain and suffering, 50,000 rupees has been awarded. Retain, that same may be retained.
The liability of the insurance company.
Liability, my lordship, pay and
The
recover, my
third
lord.
party, your lordship.
We'll order pay and recovery, Mr.
Pay and
Counsel. Yes. So far as award of amount under all heads is concerned, this court is of the view that it is reasonable. However, towards food, extra nourishment and medical attendant charges,
And amenities is on lower side as per the nature of fracture, your lordship.
globally we will increase by 20,000. Heard. You are Mr. M.V. Mahesh.
M.V. Mahesh.
Heard Sri M.V. Maheshwarappa, then counsel for the appellant, as well as Sri Mallikarjun Reddy, who represents Sri Pradeep B. Learned Counsel on record for respondent number 2 insurance company. Next. The order under challenge in this appeal is the one that is rendered by the Motor Accidents Claims Tribunal Bangalore in MVC 5210 of 2019, dated 6/4/2022. Full stop. This is a claimant's appeal. Full stop. As against the claim for rupees 10 lakhs in total, comma, the tribunal through the impugned order awarded a sum of rupees 1,68,794 as compensation. Full stop. Next. Arguing the matter, Sri M.V. Maheshwarappa, Learned Counsel for Appellant, contends that this appeal is filed on 2 grounds. Full stop. Firstly, that the tribunal went wrong in exonerating respondent number 2 insurance company from liability. Full stop. Secondly, the amount awarded as compensation is grossly low and does not commensurate to the loss sustained by the appellant. Full stop. Making his submission on the first ground, Kamal and Counsel Sri M.V. Maheshwarappa contends that the appellant sustained injuries in a road traffic accident and he is third party to the insurance policy. Full stop. On the ground that the rider of the offending motorbike was not holding valid driving license, which amounts to violation of terms and conditions of the policy, comma, the tribunal exonerated the insurance company from liability. Full stop. Learned Counsel states that as the appellant is third party to the insurance policy and should not suffer, hence the setting aside the impugned order, comma, this court may fasten liability against the insurance company also, along with the owner of the offending vehicle. Full stop. The submission that is made by Sri Mallikarjun Reddy, representing the insurance company in this regard, is that sufficient evidence was produced that the rider of the offending motorbike was not holding driving license. Full stop. However, in case the court contends, this court is of the opinion that the appellant, who is the claimant, should not suffer, comma, the court may order pay and recovery. Full stop. Next. The case of the appellant is that on the date of accident, while he was proceeding on his Honda Dio vehicle on Lal Bagh Main Road, comma, the rider of a Honda Activa vehicle bearing registration number KA02EW9375 came from opposite direction at high speed and in a rash and negligent manner and dashed against his vehicle, due to which he fell down and sustained injuries. Full stop. Respondent number 2 insurance company examined its manager as RW1, who deposited that the rider of the offending motorcycle was not possessing valid driving license. Full stop. Respondent number 2 insurance company also relied upon the contents of exhibit R6 chart sheet exhibit P1, certified copy of the order in CC, a certified copy of the order, comma, exhibit P2, certified copy of the judgment, to establish that the rider of the offending vehicle did not possess valid driving license. Full stop. The owner of the offending vehicle failed to contest the matter. Full stop. Thus, perceiving the fact that the insurance company established that the rider of the offending vehicle was not holding valid driving license, comma, the tribunal exonerated the insurance company from liability. Full stop. However, this court is convinced with the submission that is made by Sri M.V. Maheshwar Appal and counsel for the appellant that the appellant, being the third party to the insurance company, insurance policy, should not suffer. Full stop. At the same time, this court is of the view that as the terms and conditions of the policy were violated by the insured, comma, even the insurance company should not suffer. Full stop. Therefore, this court considers desirable to order the insurance company to pay the compensation which the appellant oblique claimant is entitled to, and thereafter to recover the same from respondent number 1, that is the owner of the offending vehicle. Full stop. Next. Coming to the quantum of compensation that is awarded, comma, the tribunal through the impugned order awarded a sum of rupees 1,68,794 as compensation divided under following heads. 18. Full stop. Learned counsel for the appellant submits that the evidence of PW2 clearly establishes that the disability in respect of the lip is 39% and to the whole body is 13%, but the tribunal did not award any amount towards loss of future earnings. Full stop. Land Council also states that the tribunal awarded a sum of rupees 3,200 only towards food, extra nourishment and attendant charges, which is unjustifiable. Full stop. It is not in dispute that the appellant sustained fracture of left proximal lateral tibia, which is grievous in nature. Full stop. Likewise, it is not in dispute that the appellant took treatment for the said injury as inpatient. Full stop. However, a perusal of record reveals that the appellant, who examined himself as PW1, during the course of cross-examination admitted that he was working at Ernst and Young LLP company as analyst by the date of accident, and he continued to work in the same company even after the accident. Full stop. He further deposed that he was drawing rupees 35,000 as salary by the date of accident, and as on the date of giving evidence, he is drawing rupees 49,000. Full stop. The statements thus given by the appellant himself goes to show that there was no loss of earnings due to the said disability. Full stop. However, this court is of the view that the appellant would have incurred substantive amount towards extra nourishment and attendant charges during the course of treatment. Full stop. Also, having considered the nature of injuries sustained, Common Court is of the view that the appellant would not have attended his normal pursuits at least for a period of 2 months. Full stop. Therefore, this court considers desirable to enhance the compensation globally by 20,000. Full stop. Thus, in the light of the foregoing discussion, the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 5210 of 2019, dated 6/4/2022, is enhanced by rupees 20,000. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Full stop. Respondent number 2 is directed to deposit the entire compensation within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, respondent number 2 insurance company is given liberty to recover the same from respondent number 1 by initiating appropriate proceedings. On deposit, the appellant is permitted to withdraw the entire amount.
Much obliged.
Serial number 6.
For
Syed
appellant
Abdul
in this
Sabur.
I am for
Harish Bhai.
appellant in this case, my lord.
Yes, Mr. Counsel.
Yes,
Appellant
my
is
lord,
no-
the appellant is there no more, and his LF has been brought on the court. He expired on 9/1/24. I filed a memo of death, memo reporting death along with legal representatives. On
Any
And-
objection?
No, madam.
IA 1 of 2024 is filed seeking the court to permit the legal representatives of the deceased appellant to come on record. Heard, P. Syed Abdul Sabur, learned counsel for the applicants who appears through VC, full stop. Also heard Sri Ravish Benny,
My name Jagdish PS on behalf of.
also heard Sri Jagdish PS, learned counsel who represents Sri Ravish Benny, learned counsel on record for respondent number 2, and who appears before this court physically. Full stop. Gone through the contents of the affidavit given in support of the application. Full stop. Learned counsel Sri Syed Abdul Sabur submits that the first applicant is the wife and the applicants 2 and 3 are the children of the deceased appellant, and except those persons, there are no other legal heirs to the deceased appellant. Full stop. The record discloses presence of copy of death certificate in respect of the deceased appellant. Full stop. No objection is raised by Sri Jagdish HT,
PS. PS, my lord.
Sri Jagadish PS,
Yes.
learned counsel who represents respondent number 2 for allowing the application. Full stop. Thus, the petition is allowed. Full stop. The petitioners are permitted to come on record as the legal representatives of the deceased appellant. Next. Necessary amendment to be carried out in the memorandum of the appeal. Need copy to be filed. List on 22nd October.
Nachabru.
Serial number 7, NR Rangegowda.
I appear for appellant counsel, my lord. I appear for appellant counsel, my lord.
Why 2 names are shown? SV Hegde Milton and EA Sanmati.
Yes, and what? Yes, and what?
Hmm?
Yes, and what?
SV Hegde Milton.
Yes. On 12th June, latest.
Await the records from the tribunal. Full stop. Office has shown Sri SV Hegde, the names of SV Hegde Milton as well as Sri EI Sanmati for respondent number 2. Full stop. Office to verify and to reflect the name of the learned counsel who is appearing for respondent number 2. List on 22nd October.
Please.
Serial number 8, Pancham RD.
For the appellant in this case, my lords. My lords, I pray for a week's time, my lords, to take steps, my lords. Appeal is arising under section 30 of the Employees Compensation Act, my lords. Respondent was the claimant before the trial court. My lords, the amount award.
Not furnished the requisites.
My lords, last time, my lords, on 7/3/2024, my lords, notice was issued and the impugned order was stayed, my lords.
And counsel Sri Pancham RD.
Please, my lords.
Appellant seeks a week time to furnish the requisites. Full stop. Time as prayed for is granted. On furnishing the requisites, office to send notice to the respondent. List on 29th October.
Grateful.
Serial number 9, Satisha T.
Small submissions. Para number 26 of the judgment. Wrongly shown in the our trial court award 7 lakh 75,900 in order portion. Mal. Three connected matters.
Pera?
Page number 26 and 27. 27 ಅಲ್ಲಿ order portion ಅಲ್ಲಿ MEC 259/22 wrongly shown in typographical error 7,75,900. The correct award amount is 7,70,800 only. Only one submission.
So the court held that at para 42, 7,70,800.
Yes, my lord.
But in the order it held that 7,75,900.
900 wrongly shown in typographical error.
Get it corrected.
Kindly refer to Lok Adalat in all connected three matters.
First you get it corrected, Mr. Counsel.
Only one single objection, ma'am. Kindly objection over.
No, Mr. Counsel, the amount is different. Sri Satisha T seeks time to get the typographical error corrected in the impugned order. Hence, list on 29th October.
Serial number 10, A. Shantaraj. R1 notice may be dispensed with. Next.
Yes, Mr. Counsel.
R1 notice may be dispensed with since liability has been admitted by the insurance company.
Heard, Sri Shantaraj K. Learned Counsel for the appellants. Full stop. Learned Counsel files a memo seeking dispensation of notice upon respondent number 1. Full stop. Learned Counsel submits that as respondent number 2 admitted its liability, a notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, a notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Sri P.B. Raju is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Sri P.B. Raju. List on 29th October.
Next matter,
Serial number
R1
11.
notice may be dispensed with
Second response.
and TCR may be called.
Yes. Where is the memo?
Memo, 8343. ಇಲ್ಲ ಮೆಮೊ ಕೊಟ್ಟಿಲ್ಲ ಕೊಡ್ಲಿಲ್ವಾ ಇಲ್ಲ ಒಂದೇ ಇದೆ I will give mail. I will give.
Yeah. 8343 of 23.
8343. Sorry, I will furnish my.
Same order, memo file seeking dispensation of notice. Land council submits it so and so. Then, Sri C. Shankar Reddy, for respondent number 2 is present. Full stop. Will admit the matter, Mr. Counsel. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 5th November.
Next matter, yesterday I paid PF man.
Shantara, serial number 12.
Yesterday I paid PF.
Land counsel for the appellants, Sri Shantaraj case submits that requisites were furnished and the needful is done. Stop office to verify and to send notice to respondent. List on 12th November.
Serial number 13. Gopal Krishna N.
We have opened this case, my lord. Acceptance of note below cause settled with respect to LRs of deceased. We have filed death certificate, my lord. Petitioner number 5. In MACT. Yes. Kindly, it may
How to
be.
move an application, Amma?
Memo, I kindly have mine. I have my lord, memo to
What is it?
consider appellant 1 to 4 as LRs of.
Have to file an application. You have to file a petition. You have to file a petition along with the death certificate to show.
Death certificate is filed, my lord.
File a petition. We have to pass orders. Yes, heard. Miss Susmita, who represents Sri Gopal Krishna N, learned counsel on record for the appellants. Stop. Learned counsel seeks time to file appropriate application for recognizing the legal representatives of the deceased appellant number 5. Full stop. Hence, list on 22nd October.
Much obliged.
Serial number 14, Gurudev Prasad. Appellant in this case, file a memo to withdraw the.
You are Mr. Gurudev Prasad?
No, I'm colleague. He is my senior.
Huh?
He is my senior.
What is your name, Mr. Counsel? Your good name?
Satyapal Hegde.
Huh?
Satyapal Hegde.
Heard Sri
Satyapalaya.
Satyapalaya, who represents Sri Gurudev Prasad KT, Land Council on record for the appellant. Full stop. Land Council seeks permission to withdraw the appeal. Full stop. Memo filed to that effect is also on record. Full stop. Permission as prayed for is accorded. Appeal is dismissed as withdrawn.
Serial number 15. Yes, Rajaram. Here, Abhishek.
I'm for the appellant, my lord.
Yes,
One
showing two
The-
names.
delay is only 149 days, my lord.
Huh?
The IA for condemnation of delay is only 149. Please
In this matter, neither Sri A. Ravi Shankar nor C. Shankar Reddy have filed wakalat for respondent number 2 till now. Full stop. Hence, issue notice to respondents 1 and 2 on furnishing the requisites in the appeal
May-
as well as in IA 1 of 2022.
My lord, we already filed memo for dispensation for respondent number 1.
No,
Open court 180.
no memo for dispensation. Yes, list on 12th November.
Bill number 16, FS Dabali, Shripad V Shastri.
I am for appellant, my lord. I filed an application for return of TCR. My lord, last week it was posted and my lord decided to dispose of the matter. My lord, all the compensation is to be recalculated. Case of death, my lord.
Yes, Mr. Council.
Here, madam, there are two appeals, madam, one by the corporation and another by the claimant.
Yes.
It is a case of death, madam. The appeal has been filed by the corporation. By challenging not the finding of the tribunal at the point of negligence, madam, he was a
So in both the appeals, quantum is in dispute.
Yes.
quantum, my lord, yes,
It
madam.
is to be recalculated, my lord.
Quantum and negligence, madam, on the point of negligence.
Because the bachelor's death, the 2/3 is considered as loss of it is to be 50%.
Yes, Mr. Council, you may appear physically and argue the matter, Mr. Council. In final hearings, we are feeling difficulty to hear through VC. So far as interlocutory applications or grant of adjournments are
Well, it
concerned.
may be because I am a senior citizen now and I am far away from the court. Well, my presence may be dispensed with and I have to attend at least 3-4 courts at once. That's why.
You may give a convenient date. So far as final hearings are concerned, you may give a convenient date.
My IA for return of TCR may be allowed. TCR may be returned back.
When the other side reports ready for hearing, how can we return the transcript? Yes. Admit and list both the matters under the caption final hearing on.
TCR may be returned, my lord. At least order sheet and wakalat.
Mr. Council, we will hear the matters and thereafter we'll return the trial. Again, fetching them will be a laborious work for both.
My lord,
list on. Can it be on 11th, Mr. Council?
my lord, physical presence, my lord, it is very difficult for me, my lord. At least 3 or 4 courts I have to attend. It is my lord. If my lord, only my humble request is, my lord, I will continue the argument. Suppose if it is my lord found it is difficult, my lord, I will definitely I will come in person because it is only a calculation. It is only a calculation. 2/3 in the case of death of a bachelor, 2/3 is considered as
Mr. Council, you may give your convenient date for attending the court.
My lord, I can't because my lord, on the previous day, my lord, the list will come. That is why today
On the
it's
date given, the matter will be listed, Mr. Council. On the date given, the matter will be listed.
my lord, not this court, my lord. The other courts, my lord, I have to attend. If I come with the physical, I have no juniors. That is why, my lord, I am requesting my lord to consider my humble request. If suppose my lord find it difficult, my lord, definitely I will come in person. Otherwise, I will come in VC, my lord. My only humble request, my lord.
Pass over the matters. We'll see at 2:30, Mr. Council. Yes, pass over.
Pass on. Serial number 17, Ravi S. Samprati, Shankar MR for R1.
Respondent number 1.
Respondent number 2 and 3, sir.
Lord, I have filed an IA to release the amount deposited before the trial court by the appellant.
Yes, Mr. Council.
I have filed a IA 1 of 24 to release the amount deposited by the appellant before the trial court, my lord.
I represent on behalf of Ravi Samprati, my lord, appellant advocate. My lord, in last occasion, TCR is called for, my lord. They challenge the liability. Matter after receipt of TCR, my lord, matter may be finally disposed of, my lord. Any date may be fixed.
Have you deposited the amount?
As per the instruction, they have deposited, my lord. That's why they have
Deposited, I have.
they have deposited, my lord. So date may fix, my lord, after TCR is received, my lord. It may be disposed of, my lord.
Records
No,
were
my lord,
called
from
forward.
last 3 occasions, the same submission was made by the.
It's called in last date, my lord. On 22/8/24, my lord, if I am correct.
Because he is unable to attend the work, my lord, the respondent number 1. In the meanwhile, it may be ordered to receive, withdraw the amount, my lord.
Await records from the trial court, from the
My lord,
consent
it was,
tribunal.
it was deposited on 18/8/2023.
Say that they are disputing the
Challenge
liability
liability,
itself. How can we permit, let the records be received? Await records from the consent tribunal. List on 22nd October.
Please.
My lord,
Next.
maybe too long date, my lord.
Yes.
Serial number 18, Ashok N. Patil, Rangegowda NR for responding.
Good for the appellant in this case.
Here for response, counsel, Rangegowda.
Notes in this appeal, notes are questioned notes with regard to liability and negligence.
Yes. Where is the other, where the other matter?
Filed the memo, my lord, R1 and R3, kindly notice may be dispensed with.
Why the notice has to be dispensed with?
My lord, liability fixed on respondent number 2 and 4, my lord. They are challenging the only negligence to.
Heard Sri KV Nayak, Land Council who represents Sri Rangegowda NR, Land Council for the appellant in MFA 108 of 2024. Full stop. Memo seeking dispensation of notice upon respondents 1 and 3 is on record. Full stop. Land Council Sri KV Nayak submits that as liability is fixed upon respondents 2 and 4, comma notice to respondents 1 and 3 may be dispensed with. Full stop. Having considered the submission thus made, comma notice to respondents 1 and 3 is dispensed with, however, at the risk of the appellant. Next, admit both the appeals. Records are required.
Yes.
Call for the records from the consent tribunal. List both the matters under the caption final hearing on 29th October.
Please,
Yes.
my problem.
Four.
Who is for R4 in the other matter?
B. Pradeep may be directed, but that is Liberty General Insurance Company. He is representing Mallards in my appeal. B. Pradeep.
As 3, B. Pradeep is appearing for respondent number 4 in the connected appeal, that is in MFA 1050 of 2024, comma Sri B. Pradeep is called upon to accept notice for respondent number 4 in MFA 108 of 2024 also, and file wakalat, full stop. Wakalat to be filed within 2 weeks. List on so on, sir.
Serial number 19, KT Gurudev Prasad.
Yes. I filed a memo. They'll dispense the notice 2 and 4. They are the owner of the vehicle. There is no report regarding the liability.
Why we have notice has to be dispensed with?
2 and 4 are owner of the vehicle. There is no.
Heard. Sri
HR Satyapal Hegde.
Sri
Satyapal.
Satyapal,
Hegde.
Land Council who represents Sri Gurudev Prasad KT, Land Council on record for the appellant. Full stop. Land Council files a memo seeking dispensation of notice upon respondents 2 and 4. Full stop. Land Council submits that as the liability is fixed upon respondents 1 and 3, comma notice to respondents 2 and 4 may be dispensed with. Full stop. Having considered the submission thus made, comma notice to respondents 2 and 4 stands dispensed with, however, at the risk of the appellant. Next. Sri E.I. Sarmati is called upon to accept notice for respondent number 1. Subject to entrustment of the case otherwise by respondent number 1. Srimati Harini Shivanand is directed to accept notice for respondent number 3, subject to entrustment of the case otherwise by respondent number 3. Wakalats to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri E.I. Sanmati and Srimati Harini Shivanand. List on 1911.
Serial number 20, Shankar Reddy.
Appellate. The insurance appeal challenging the liability on the ground that insured vehicle had no permit on the date of accident. I am ready to deposit 50% of the award approval. Also, there is a delay of 32 days in filing the appeal.
Third, Sri Shankar Reddy C, Land Counsel for the appellant. IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Additional Motor Accidents Claims Tribunal 11, Bhadravati, in MVC 889 of 2022, dated 5/3/2020. On what ground you are disputing your
Permit violation.
Land Counsel Sri Shankar Reddy C submits that though there was violation of terms and conditions of the policy, yet the tribunal fastened liability against the petitioner appellant and therefore appeal is filed. Mr. Land Counsel thereby seeks to stay the operation of the impugned award. Mr. Having considered the submission thus made, this court is of the view that stay as preferred is required to be granted, however conditionally. Thus, the operation of the award that is passed by the Additional Motor Accidents Claims Tribunal 11 Bhadravati in MVC 889 of 2022 dated 5/3/2024 shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, the registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Next, issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 19th November.
21, MV Maheshwarappa.
In this case, here for appellant, I filed the above appeal for enhancement of the compensation. Exhibit P22, as per the evidence of owner, that is the RWO 2 is 15,000.
Let us issue notice.
Ah.
Issue notice to respondent number 1 in the appeal as well as in IA 1 of 2024 on furnishing the requisites. Sri S.V. Hegde Mulkund is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the appellants to serve at the chambers of Sri S.V. Hegde Mulkund. List on 19th November.
Serial number 22, Gopalakrishna N.
Proxy counsel appearing for representing. Lordship. The respondent number 1 is the owner of the offending vehicle, my lordship. Maybe dispensed.
Yes, heard. Sri T. Vijay Kumar, who represents Sri Gopal Krishna N, Land Council on record for the appellants. Full stop. Land Council files memo seeking dispensation of notice upon respondent number 1. Full stop. Land Council submits that that as liability is fixed upon respondent number 2, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
R2 is the national insurance.
Sri Ashok N. Patil is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Sri Ashok N. Patil. List on 19th November.
Serial number 23. N. Gopal.
Appellant, my lordship. R1 is the owner of the appellant.
Same order, heard Sri T. Vijay Kumar, Land Council, who representing Gopal Krishna. Where is the memo? Memo file seeking this.
R2 is Shriram General Insurance.
Sri B. Pradeep is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed with me. These are copies of appeal. Same day.
Please.
Serial number 24, Vinod Gowda.
Yes, appellant here. Owner of the vehicle has filed his appeal. There is no insurance. Here, petitioner died during the pendency of the petition. He has died due to the heart attack. It is admitted by his wife. Hence, there is no nexus between death and the injury. The tribunal has awarded 2,30,000 medical bills. Hence, I sought for stay.
You are Mr. Vinod Gowda.
Yes, ma'am.
Heard. Sri Vinod Gowda, Land Council for the appellant.
25%. She is a poor lady.
IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MBC 5956 of 2017, dated 8/11/2023. Mr. Land Council Sri Vinod Gowda submits that the petitioner appellant is the owner of the vehicle which is involved in the accident. Full stop. Though the deceased Nagaraju died due to heart attack and not due to the injuries sustained, yet the tribunal fastened liability against the petitioner appellant, and therefore this appeal is therefore the appellant filed an appeal challenging the order. Full stop. Land Council thereby seeks to stay the operation of the impugned award. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Full stop. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 5956 of 2017 dated 8/11/2023 shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount
25%.
along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, my fixed deposit scheme.
10,000 already paid.
Yes, issue notice to the respondents in the appeal as well as in IA 2 of 2024 on furnishing the requisites. List on 19th November.
Number 25, KT Gurudev Prasad.
No. R2 may be dispensed. There is no dispute regarding the liability.
Heard Sri
Satyapal.
Satyapal, Land Council who represents Sri Gurudev Prasad KT, Land Council on record for the appellant. Land Council files memo seeking dispensation of notice upon respondent number 2. Land Council submits that as liability is fixed upon respondent number 1, notice to respondent number 2 may be dispensed with. Having considered the submission thus made, notice to respondent number 2 stands dispensed with, however, at the risk of the appellant. Next. Sri D. Vijay Kumar is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers.
One submission, my lord.
Yes,
In
Mr.
serial number 25, my lord. My lord, serial number
Yes,
25, my lord.
Yes, 25.
My lord, my name, I'm not interested in that company.
You are not on
Bajaj
record.
Alliance.
Bajaj
Yes, yes, ma'am. I am there in the panel, but I am not taking the cases.
Okay.
Kindly enter some other case.
Sri
Renuka is there.
is Sri P.S. Jagadish appear.
P.S. Jagdish is there.
Yes, Jagdish.
Sri P.S. Jagadish is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by appellant to serve copies of appeal papers at the chambers of Sri P.S. Jagadish. List on 20th 20.
Serial number 26, KV Nayak.
I appear for appellant, madam. Claimants appeal for enhancement. Case of injury. Respondent number 1, madam, kindly notice may be dispensed with, madam.
Heard Sri K.V. Nayak, Land Council for the appellant. Memo file seeking dispensation of notice upon respondent number 1. Land Council submits that has respondent number 1 remained ex parte before the tribunal. Hence, notice to respondent number 1 may be dispensed with. Having considered the submissions thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Sri A.N. Krishnaswamy is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri A.N. Krishnaswamy. List on 20th November. Yes.
Number 27, B Pramod.
Appearing for appellant, my lord. The case has been dismissed in lower court. So this
Heard. Your good name, Mama?
Deepu.
Heard. Miss Deepu, who represents Sri B Pramod, Land Council on record for the appellants. Issue notice to respondent number 1 on furnishing the requisites. Only four standing councils are there for Sriram General Insurance. Only four are there. Sri O Mahesh is not attending. He's not attending. Sri B.C. Shivanagoda is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri B.C. Shivanagoda. List on 20th November.
Bill number 28, R. Shashidhara. Serial number 28.
No representation on appellant side on call. Hence, stand over to 3rd December.
Bill number 29, H.C. Rishabhendraya.
By the insurance company, my lord, on the ground of quantum, I'm filing a dispensation memo for R5, my lord.
Third, Sri H.C. Rishabhendraya, Land Counsel for the appellant. Land Counsel files memo seeking dispensation of notice upon respondent number 5. Full stop. Land Counsel states that as no relief is claimed against respondent number 5, comma, notice to respondent number 5 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 5 stands dispensed with, however, at the risk of the appellant. Respondent number 5. Yes.
Challenging the quantum, my lord.
Yes. So why you have filed an application for stay?
Yes, I have filed, my lord. Stay application.
Stay application.
I one for stay, my lord.
Yes. Why you file this application for stay on what ground?
My lord, in this case, all our major sons, daughters, they are not entitled for one. The tribunal has directed 1/3. They are not dependent on the income as per the evidence. And I'm challenging the quantum granted by the tribunal, my lord.
IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Additional Motor Accidents Claims Tribunal 6 Shivamogga in MVC 296 of 2022, dated 27/3/2024. Land Counsel Sri H.C. Rishabhendraya submits that though the claimants 2 and 3 are the major sons of the deceased and were not depending upon the earnings of the deceased, the tribunal awarded huge sum as compensation, taking those persons also to be the dependents of the deceased. Full stop. Land Counsel thereby seeks to stay the operation of the impugned award. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Full stop. Thus, the operation of the award that is passed by the Additional Motor Accident Tribunal 6 Shivamogga shall stand stayed until further orders on the appellant depositing the share of the first claimant that is 6,38,600 along with accrued interest within a period of 4 weeks before the tribunal. Next, on such deposit, the first claimant is permitted to withdraw 50% of it, 50% of it without furnishing any security. Full stop. The remaining amount shall be invested in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Full stop. Issue notice to respondents 1 to 4 in the appeal as well as in IA 1 of 2024 on furnishing the requisites. List on 20th November 20.
Serial number 30, Ashok and Patil.
As for the appellant in this case, the insurer appeal on the ground of minutes
Mr.
live.
Counsel,
Sir.
you sought for dispensation of notice against respondents 4 and 5.
Five only, ma'am.
Your memo is not clear. You read the memo and makes necessary corrections. Memo is not clear. Yes, next.
Serial number 30, Ashok and Patil.
Insurer appeal. Ground of minutes liability.
Yes.
This is a claim minutes filed by the minutes LRs of the deceased under section 163A or minutes now it is under 164. But he had minutes himself minutes caused the accident. Therefore, minutes the claim was not maintainable. The award minutes needs to be set aside minutes is the ground.
Heard, Sri Ashok and Patil, Land Counsel for the Appellant. IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal Bangalore in MVC 2762 of 2023 dated 18/6/2024. Full stop. Land Counsel Sri Ashok and Patil submits that though the insurance company is not liable to pay any compensation as why?
The claim petition is filed minutes under section 164 and the rider himself minutes caused the accident.
As he died,
Yes, ma'am, he succumbed
as
to
the
injuries.
deceased himself was at fault, yet the tribunal fastened liability against the petitioner appellant and therefore an appeal is filed. Land Counsel thereby seeks to stay the operation of the impugned award. Having considered the submission judgment, this court is of the view that stay as preferred is required to be granted, however conditional. On deposit of 50%, before this court, investing fixed deposit. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 on furnishing the requisites. List on 20th November.
Serial number 31, admission matters. Lalita PM. Respondents have.
No representation on appellant side on call. There was no representation. Even on 17/2/2023. Full stop. To give fair opportunity, released on 13th September.
Serial number 32, AN Krishnaswamy. DP Prasanna for R1.
Presenting on behalf of Krishna Swami, wants time and weeks time maybe.
Sri B. Pradeep, representing Sri A.N. Krishnaswamy, Land Counsel on record for the appellant, seeks time. Full stop. Hence, stand over to 19th September.
Serial number 33. Satish HK.
This case, I am for the
Sir,
appellant in
Renuka.
this case, man. I pray for a week's time in this case, man. Claim petition is dismissed, my lord.
Filling for the respondent, Lordship.
Not admitted. You are Mr. Satish HK.
Satish, yes, ma'am.
Heard Sri Satish HK, Land Counsel for the appellant. Admit. List the matter and the caption final hearing on 15th October.
Much.
Serial number 34. Shivakumar P.
My lord, in this case, my lord, P. Shivakumar is no more. Day before yesterday, he died, unfortunately.
He is no more, huh?
Yes, my lord, day before yesterday, he was suffering from, for the past 1.5 months, some ailment. Notice may be ordered. Otherwise, his colleagues are there. I don't know whether they are going to.
We are for respondent government, ma'am, KJD. This.
Sri D. Vijay Kumar appears through VC and submits that Sri Shivakumar P. Land Counsel on record for the appellants is no more. With stopping the light of the submission thus made, issue notice, registry is directed to send notice to the appellants. List on 14th November.
Much up.
Serial number 35 adjourned. 36 Sripad Shastri, Sri Shaila for R2.
But I am for appellant, my lord. They have to, Seychelles has to file the wakalat. Morning he is making some submission. But it's a case of injury only for enhancement. My lord.
Sri Sripad V. Shastri, Land Counsel for the appellant, appears through VC. Full stop. No representation on respondent side on call. Full stop. On 4/8/2022, Sri C. Shaila sought time to file wakalat for respondent number 2. Full stop. Till now, wakalat is not filed. Full stop. Also, there is no representation. Hence, issue notice to respondent number 2 on furnishing the requisites. List on 13th November.
Serial number 37 L. Srikant Rao.
My lord, I am representing Sridhar, my lord, respondent claimant.
Yes.
Serial number 37 L. Srikant Rao.
No representation on appellant side in both the appeals. To give fair opportunity, list on 25th September.
Serial number 58 Srinivasa DC. Yuvraj Patil for R4.
Respondent number 4, your lordship. 2 weeks time may be granted. 2 weeks time may be. Respondent number 4.
My lords, for petition, for the appellant, my lords.
Yes.
Yes, my lords. In this, we have sought for enhancement, my lords, because notional income should have been taken at 11,000 rupees as per when we don't give the income, proof of income.
Proceed.
Yes, my lords. 11,000 rupees, my lords. It should have been considered, but the Royal Court wrongly considered as 7,000 rupees.
For the claimant in both the appeals, huh?
No, my lords. For the second one, we are for the respondent. First, the 38 serial number, we are for the appellants.
Liability is fixed on the another, the second one. Your lordship. He is the owner of the vehicle.
My lords, liability may be shifted to the insurer, my lords, because until the registration is done, the insurer, the respondent number 4, that insurer only is liable to pay the compensation, my lords.
Your good name, Mr. Counsel?
Akshay S. for Srinivasa DC.
Heard. Sri Akshay who represents Sri Srinivasa DC, Land Council on record for respondent number 1 in MFA 7085 of 2022, who is also appearing, who is arrayed as appellant in MFA 1956 of 2022. Full stop. Admit both the appeals. You are Mr.
Shivraj Patil. R4.
Don't try to admit. No representation for appellant in MFA 7085 of 2022. Full stop. To give fair opportunity, released on 26th September.
Serial number 39, Pradeep B. D. Suresh.
Hearing for the appellant in this case.
Yes.
Lord, as directed, my lord, I had to serve the copies, but he is not appearing and he has not, no number is also not found out, my lord. Previous occasion also he is not present. The copy is ready with my hand, my lord.
Sri Pradeep B. Land Counsel for the appellant appears before this court physically. Full stop. However, there is no representation on respondent side. Full stop. Land Counsel Sri Pradeep B. submits that he could not find Land Counsel for respondents 1 to 5 to serve copies of the appeal papers. Full stop. In the light of the submission thus made and on going through the relevant material that is brought on record, admit and list the matter under the caption final hearing on 23rd October.
Obliged.
Serial number 40, Mallikarjun DR. Token party.
For respondent two in this case. Notes copy has been served on me, notes I am ready in the matter notes.
Yes.
Lord, it's a case of death, my lord. Only two grounds, my lord, I am seeking enhancement, income and also conventional aids. That is the only two ground in this.
Income
And conventional aids, my lord.
conventional.
Please. 2019 accident, 11,000 taken by the tribunal. As per the local law, 14,000 has to be added. Conventional aids only 70,000 has been awarded by the tribunal. my lord. Claimants, my lord, wife, minor child and mother of the deceased. He was aged about 34 years, deceased. By doing, my lord, business, purchasing and selling the old vehicles, my lordship. Trial, he was aged about 34 years, deceased. Age 34 years.
Who are the dependents?
My lord, dependents, wife, minor child and mother of the deceased. Third claimant.
So 1/3 is required to be
Please,
deducted.
1/3.
Multiplier is 16.
Please.
Yes, Mr. Counsel.
Please, my lords, your lordship may kindly take, my lord, the Notional income as per the my lords guidelines of,
1,000.
yes. So I have only one submission, my lords, with regard to the age, my lords. The tribunal, my lords, having relied on the my lords postmortem report, has taken the age of the deceased as 34. No other documents are produced except, my lords, the PM report. In respect of, my lords, the claimants 1 to 3 or petitioners 1 to 3, my lords, Aadhaar card have been produced. There is no, my lords, document to establish the, my lords, exact age. We have suggested and that is more than 34 years of age and it is been denied. Therefore, my lords, your lordship may kindly consider this, my lords, my submission.
Let's take as per postmortem report. Yes, we have taken the notional income as 14,000.
Yes.
Added 40% towards future prospects, deducted 1/3 towards personal expenses, applied appropriate multiplier 16. And we have awarded 15,000 towards loss of estate, towards 15,000 towards funeral expenses, 40,000 towards loss of spousal consortium, 40,000 towards loss of parental consortium, and 40,000 towards loss of filial consortium. So the total comes to rupees 26,58,800.
6 lakhs.
Heard. Three, Mallikarjun DR, Land Council for the Appellants, as well as Sri Ashok N. Patil, Land Council for Respondent number 2. Next. Dissatisfied with the amount that was awarded as compensation by the Motor Accidents Claims Tribunal, Tumkur, through orders in MVC 576 of 2019, dated 10/2/2021, the claimants are before this court through this appeal. As against the claim for rupees 60 lakhs, the tribunal through the impugned order awarded a sum of rupees 20,41,264 as compensation. Next. Arguing the matter, Sri Mallikarjun DR for appellants submits that the first appellant is the wife, the second appellant is the minor son, and the third appellant is the mother of the deceased Mohan Kumar, who died in a road traffic accident. Full stop. The deceased Mohan Kumar, within brackets, hereinafter be referred to as the deceased for brevity, brackets close, was purchasing and selling old vehicles and was also doing agriculture and thereby was earning rupees 30,000 per month. Full stop. However, the tribunal took the notional income of the deceased as 11,000 per month, which is unjustifiable. Full stop. Learned Council also submits that the tribunal awarded a sum of rupees 40,000 only under the head loss of consortium. Full stop. Learned Council thereby seeks to enhance the compensation and award the sum claimed. Full stop. Next. Learned Council Sri Ashok N. Patil, representing respondent number 2 insurance company, though did not dispute the fact that insurance company submits that the amount awarded as compensation is justifiable. Full stop. However, Learned Council did not dispute the submission made by Sri Mallikarjun DR with regard to assessment of notional income. Full stop. Learned Council Sri Mallikarjun DR submits in this regard that the Karnataka State Legal that the accident occurred in the year 2019, and for the relevant period, the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 per month, and at least set figure should have been considered by the tribunal. Full stop. The submission thus made appears justifiable. Full stop. Next paragraph. It is not in dispute that the deceased was aged about 34 years by the date of accident. Full stop. Thus, 40% of the actual earnings are required to be added towards future prospects. Full stop. Also, the dependents being 3 in number, 1/3 of the actual earnings are required to be deducted towards the personal and living expenses which the deceased would have incurred for himself had he been alive. Full stop. Also, the appropriate multiplier to be applied is 16. Full stop. On applying the set parameters, the compensation which the appellants are entitled to under the head loss of dependency is as under. Tabular form. Notional monthly income 14,000, annual income 1,68,000. Add 40% towards future prospects 2,35,200. Deduct 1/3 towards personal and living expenses 1,56,800. Apply on applying appropriate multiplier 16, loss of dependency is 25,08,800. Full stop. Next. Thus, the loss of the compensation which the appellants are entitled to under the head loss of dependency is 25,08,800. Full stop. Together with the said amount, the appellants are entitled to rupees 15,000 towards funeral expenses and 15,000 towards loss of estate. Full stop. Also, the first appellant being the wife of the deceased is entitled to rupees 40,000 towards loss of spousal consortium, the second appellant being the child of the deceased is entitled to rupees 40,000 towards loss of parental consortium, and the third appellant being the mother of the deceased is entitled to rupees 40,000 towards loss of filial consortium. Full stop. Thus, the total compensation which the appellants are entitled to is as under. Loss of dependency, 25 lakhs 8,800. Funeral expenses, 15,000. Loss of estate, 15,000. Loss of spousal consortium, 40,000. Loss of parental consortium, 40,000. Loss of filial consortium, 40,000. Total 26 lakhs 58,800. Full stop. In the light of the foregoing discussion, the appeal is disposed of with the following order. Full stop. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Tumkur, through orders in MVC 576 of 2019, dated 10/2/2021, is enhanced from 20 lakhs 41,264 to 26 lakhs 58,800. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of the order. Full stop. Next, the apportionment made remains undisturbed.
So wakalat to be filed.
Time for a week is granted to Sri Ashok N. Patil to file wakalat for respondent number 2.
Seal number 41, R. Gopal, B. Pradeep for R2.
I am for respondent number 2, my lord. Claimant file one more appeal, my lordship.
Claimant. There is another appeal, my lord. 3464 of
3464 of 22.
And one more thing is, my lord, records may be secured because there is medical bills, my lord, several bills are produced. It is not calculated as per the bills. That is the one of the grievance, my lord.
Sri R. Gopal for appellant submits that MFA
3464.
Oh.
22.
22 is connected to the present appeal. Seeks to list both the appeals on the same day. Full stop. Registry to verify and to list the present appeal along with MFA so and so on 29th October.
Please, my lord. Much
Copy
obliged.
of the records from the consent tribunal in the meantime.
Much obliged.
Seal number 42, Shivkumar P. BC Shivannegowda.
P. Shivkumar is no more, my lord. Matter may be 4 weeks, may be adjournment.
Sri Mallikarjun Reddy, Land Council submits that Sri Shivkumar P is no more. Full stop. In the light of the submission thus made, registry to send notice to the appellant. List on 12th November.
Please, my lord. Much obliged.
Seal number 43, Radha BP, Pradeep B for respondent.
I am for respondent number 1, my lord. Is the damages vehicle claim, my lord. All for TCR, my lord.
For appellant matter, my lord, the matter may be kindly passed over, my lord. My senior is held up in another court.
We'll admit and call for the record.
Please, my lord.
Your good name, Mama?
Radha Bidi.
You are on record.
Your name. Your name.
Anusha Raj.
Heard. Miss Anusha, Land Council who represents Srimati Radha BP, Land Council on record for the appellant. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 29th October.
Much obliged, ma'am.
Seal number 44, Kantarajappa MG. HR Renuka for R1.
Paying for the respondent.
The connected another MFA, my lord, connected MFA number 3613 3555 3616/22 are connected. And
But you are Mr. Kantaraj MG.
please,
Heard. Sri Kantarajappa MG, Land Council for the appellant. Full stop. Land Council submits that MFA so and so, how many matters are there?
3 matters.
And so and so are connected to the present. Full stop. Registry to verify and to list on
And
22nd October.
and call for adjournment, please.
Serial number 45, Nagaraj Reddy,
For the appellant, my lord.
Ashok Naik for R2.
Case,
For the respondent number.
case of death, my lords, on two grounds. One, my lords, the medical bills, complete medical bills have not been granted, my lords. On the ground, my lords, medical bills have not been produced.
You filed a petition for production of additional evidence.
Yes, my lords, the
Yes,
medical.
we'll admit and
IO
disqualify.
copy has not been done.
I'll give.
Heard Sri Nagaraja Reddy D, Land Counsel for the appellant. Admit. List the matter under the caption final hearing on 23rd October.
Records be called for.
Records
That's
already
received.
received.
Please, please. my lords.
Number 46 adjourned, 47, A. Venkatesh, Anand RV.
And for respondent.
The insurance have filed an appeal. my lord.
No representation on appellant side on call. Sri Anand RV,
Respondent.
Land Counsel for respondent number 1 is present before this court physically. Full stop. To give fair opportunity, list on 26th September.
Serial number 48 adjourned, 49, Gopal Krishna N. PC Shivannegowda.
For the appellant.
Behalf of BC Shunagada, I am representing my lords.
Ashok.
Yes, Mr. Counsel.
Lordship, kindly direct the learner friend to furnish a copy in connected appeal, Lordship.
I will serve my lords.
We'll admit both the appeals and list.
Please,
the
my lord.
Please.
Heard. Sri T. Vijay Kumar, who represents Sri Gopal Krishna N. and counsel on record for the appellants in MFA 8146 of 2022. Full stop. Also heard Sri Mallikarjun Reddy, who represents Sri BC Shivannegowda, land counsel on record for the appellant in MFA 1091 of 2023. Full stop. Both the appeals are admitted. List both the matters under the caption final hearing on
In connected matter.
R5. What about R5? Don't. What about respondent number 5?
Take steps, my lords. I will take steps to respond number.
Notice to respondent number 1 was dispensed with in the connected matter.
We will take steps, my lord. Respond number.
Verify, we'll pass over the matter.
Please, my lord.
But that we cannot. We'll
Please.
call at 2:30.
Please.
Respond
Please,
to
ma'am.
dispense with, you file the mail. Yes. Pass it.
Serial number 50, D. Vijay Kumar, Tejas N for responding.
For the respondent. Lord, I have filed an application, my lord, for withdrawal of the amount. It has been
Who
deposited
is
by the.
respondent number 1? Respondent number 4?
Well, respondent number 4 is the owner. I am the claimant, I am appearing for the claimants.
No representation on appellant side on call. Sri Teja S.
Tejas N.
Tejas N.
Please.
Land Council for respondents 1 to 3 submits that he moved an application by IA 1 of 2024 for withdrawal of the amount. Full stop. To give fair opportunity for the appellant to make his submission on IA 1 of 2024, list on 12th September.
Please. Oblige.
Serial number 51, Uttur Padmavati, G. Lakshmish Rao.
Case of injury, records ಬೇಕಾ?
I appear for the appellant, my lords.
There's one office objection which we would like to point out. my lords. The
Page
submission,
13 of the judgment.
please. Internal page 13. The signature of the learned presiding officer is not forthcoming. However, in the other page, it is.
This is the main thing
In the next page, it is there. Kindly see.
where judgment, where the,
Next page will watch me kindly see. In the award also, it is there.
is any objection?
No, I have no objection.
Heard. Sri Ashok N. Patil, who represents Sri Uttur Padmavati, Land Council on record for the appellant in MFA 379 of 2023. Also heard Sri G. Kamesh Rao, Lakshmesh Rao, Land Council who represents the appellant in MFA crop 85 of 2023. Full stop. Having considered the submission of Sri G. Lakshmesh Rao that the signature of the presiding officer is found at page 14 of the impugned order, the office objection is overruled. Full stop. Next. Srimati Uttur Padmavati is called upon to accept notice for the respondent in MFA crop 85 of 2023 and file wakalat. Wakalat to be filed within 2 weeks.
Okay.
We'll admit both the matters. We'll admit both the matters.
Yes.
Admit both the matters. Both the matters are admitted. Records are required.
Yes, records are.
Got the records from the consent tribunal. List both the matters under the caption final hearing on 23rd October.
Serial number 52, KV Nayak, Udindra Bhatt. Be
I
present
appear for
R2.
appellant, my lord.
I am for respond number 2, my lord.
Claimant's appeal, my lord. Lord, claim petition is dismissed, my lord. Kindly in this matter admit and post for hearing, my lord.
Heard Sri KV Nayak, Land Council for the appellant, as well as Sri Mallikarjun Reddy, who represents Sri Sudhindra Bhatt, who represents Sri Pradeep B, Land Council on record for respondent number 2. Full stop. Admit. Call for the records from the consent tribunal. List the matter under the caption final hearing on 5th November.
See, my lord.
Number 53, Sushmita, GS Marulaya for R2.
Presenting Sushmita. Kindly have it next week, my lord, due to personal convenience.
Sri T. Vijay Kumar, representing Miss Susmita G. Land Council on record for the appellant seeks time for representation on respondent side. Full stop. Hence, list both the matters on 30th September 30.
Please.
Serial number 54, Tejas N. Padmaja BS for respondent.
I represent BS Padmaja for R2.
Mr. Council, you are not visible, Mr. Council.
I am R Govindarajan.
Yes, Mr. Council,
I
you let-
represent BS Padmaja for R2.
ಸರ್ ಸ್ವಲ್ಪ ಹಿಂದ್ಗಡೆ ಹೋಗಿ ಬ್ಯಾಕ್ ಸೈಡ್ ಲೈಟ್ ಇಲ್ಲ ನೋಡಿ ಡಾರ್ಕ್ ಇದೆ ಲೈಟ್ ಹಾಕು ಕತ್ಲಿದೆ
Mr.
ಚೇಂಬರ್
Yes,
ಈಗ
Mr.
ಸರಿ ಇದೆ
You are
ಈ ಕಡೆ
visible
ಬೆಳಕಿಗೆ
now.
ಕೂತ್ಕೊಳ್ಳಿ
Yes, thank you. Yes.
Please, my lord. Lord, this is an appellant, where
That-
the injured person.
She,
my lord, has
no,
required an
BS
appeal.
Padmaja seeks for a short accommodation. She is out of station. Maybe next week, Your Lordship.
Only quantum I am challenging.
Yes, she is on a medical emergency as
Tejas N,
compromised.
Land Council for the appellant. Full stop. Sri Govindarajan appears through VC representing Srimati Padmaja BS, Land Council on record for respondent number 2. Full stop. Admit, list the matter under the caption final hearing on 18th September.
Please. Publish.
Much obliged.
Serial number 55, T. Vijay Kumar, HC Vrishabhendraya.
Insurance company has filed appeal challenging with regard to the negligence, my lord. They have filed appeal for enhancement, my lord. In this case, only point only, my lord. The petitioner himself admitted in the cross examination that he do not have a driving license, my lord. And no insurance for this motorcycle. And the accident happened. Except petitioner, no other witness has been examined to substantiate that there is a negligence on the part of the offending vehicle, my lord. And doctor has not been examined.
Lashik. The accident took place on 4/11/2019. Taken treatment for a period of 11 days. There are 5 injuries, my lordship. And the doctor was not examined in order to prove the loss of income. The compensation awarded under the head of loss of amenities and pain and suffering on lower side, my lordship. Also, my lordship, to loss of future medical expenses, the 20,000 on lower side, my lordship.
Charge sheet is filed against A2, my lord. No license and no insurance for his vehicle. First point, my lord. And also he has to keep his vehicle ahead of moving the other vehicle. So he himself dashed against the rear portion of the offending vehicle, my lord. You knew of the judgment of Supreme Court. Says one judgment is there, my lord. This says with respect of road regulation 23, rash and negligent driving, distance between the vehicles, plea of the claimant that the car colliding with truck on account of sudden application of brakes by the truck driver, truck moving ahead of the car, failure of driver of the car to keep sufficient distance between the two vehicles. No evidence indicate that the driver of the truck suddenly applied the brakes in the middle of the road. Rash and negligent cannot be attributed to the truck driver. And also another judgment. With respect of driving license.
ವಕಾಲತ್ ಇಟ್ಕೊಳ್ಳಿ ಎಷ್ಟು ಸುಮ್ಮನಾಗಿದೆ ಮಾಡ್ತೀರಾ.
And one more judgment of our division bench. If the petitioner has no driving license and no insurance, 20% contributory negligence has been fixed against him. Para 4, my lord.
Lordship, the
Doctor has not been examined.
the accident took place due to the rash and negligent driving of the offending vehicle, driver of the offending vehicle, my lordship. While taking reverse, my lordship, the accident taken place, my lordship. The and as per exhibit P7, my lordship, charge sheet.
Yes. Yes.
While taking reverse, the accident, alleged accident has taken place entirely rash and negligent driving of the driver of offending vehicle, my lordship. The tribunal has rightly fixed the entire liability on the against the insurer of the offending vehicle, my lordship. And the quantum of income, my lordship, awarded on lower side, my lordship.
How can
Towards
it be, Mr. Counsel?
towards loss of immunity is only 20,000 on. Is very meager, my lordship. And loss of income, my lordship. Towards
Have not examined even the doctor.
No, doctor has not been examined.
towards laid up period, my lordship. Towards laid up period, not even awarded, my lordship. Immunity is only 10,000, my lordship. Kindly see the nature of injury, my lordship. There are 5 grievous injuries, my lordship.
What do you say about quantum, Mr. Counsel?
Quantum. My lord, they have not proved that. And first point, my lord, mere production of driving wound certificate is not enough. To substantiate that, they have to examine the doctor who issued the wound certificate and produce all the material before the court to substantiate, sustain all the fractures. And no X-rays has been produced, my lord. At para 16, my lord. No X-rays. Discharge summary has produced. Medical bills he has produced, my lord.
Yes, Mr. Counsel.
Lordship, wound certificate as per exhibit P6.
Yes,
The injuries are in grievous in nature, my lordship. But the tribunal awarded
Certificate, such an amount is awarded as
only
compensation.
40,000 was awarded.
We have to, we find
My
no
lordship,
grounds to
under,
interpret both the appeals.
under-
We are dismissing both the appeals.
Negligence in order of driving license.
What is there? Only because he is not having driving
Yes,
license,
yes, yes.
it cannot be said that he is negligent.
Yes, yes.
You should produce some other evidence to show that the absence of driving license and skills on his part contributed for the
Yes, yes.
accident to occur. It's heard. Sri Vijay Kumar T, Land Counsel for the who is this Vasu K?
Connected.
In the
Vasu
connected
K, yes.
note.
Representing the Vasu K, my lordship.
Land Counsel who is appearing for the appellant in MFA 4645 of 2023, who also represented, where is the connected note? Sri Vasu K, Land Counsel on record for the same party, who is arrayed as respondent number 1 in MFA 949 of 2020.
No, madam.
Sir.
Full stop. Also heard Sri H.C. Rishabhendraya, Land Counsel, who is representing the appellant in MFA 949 of 2023, and who is arrayed as respondent number 1 in the connected appeal, that is MFA 4645 of 2023. Both these appeals arise out of the order that is rendered by the additional motor accidents claims tribunal for Chitradurga in MVC 642 of 2020 dated 19/4/2022. Full stop. While, next, for the sake of convenience of discussion, the contesting parties to the proceedings would be hereinafter be referred to as the claimant and insurance company. Next pyramid. While the insurance company filed an appeal disputing its liability to pay compensation on the ground that the claimant was at fault and negligence lies on him, comma, the claimant filed an appeal seeking enhancement of compensation. Next. The manner of happening of accident as per the version of the claimant is that on 4/11/2019, he was proceeding on a motorcycle bearing registration number KA06EK 3261 towards Dodda Chelluru village. Full stop. He was riding the motorcycle in a moderate speed on the left side of the road by observing traffic rules. Full stop. At that time, a bus bearing registration number KA16C 7088 was moving ahead of him. Full stop. The driver of the bus suddenly applied the brake, comma, stopped the bus, and thereafter, without giving any signal, took the bus in the reverse direction. Full stop. The claimant could not control this vehicle and thereby dashed to the hind side of the bus and sustained injuries. Full stop. Arguing the matter, next paragraph, arguing the matter, H.C. Vishabendraya, representing the insurance company, contends that the claimant was not possessing any driving license to drive the motorcycle by the date of accident. Full stop. The claimant, who examined himself as PW1, admitted during the course of cross-examination that he was not possessing driving license to drive the motorcycle. Full stop. Thus, the whole negligence lies on part of the claimant only. Full stop. But the tribunal, without considering the said fact, fastened liability upon the insurance company. Full stop. As the claimant was riding the motorcycle without having any license, comma, the insurance company is not liable to pay any compensation. Full stop. Contradicting the said submission, comma, Sri Vijay Kumar T submits that the insurance company has insured the bus which is involved in the accident. Full stop. The driver of the bus drove the bus in a rash and negligent manner, comma, stopped the bus suddenly and tried to take the bus in the reverse direction, due to which the appellant who was the claimant who was riding the motorcycle behind the bus, hit the bus, and thus the accident occurred. Full stop. And counsel also states that charge sheet was laid after due investigation with an observation that the driver of the bus was at fault. Full stop. Therefore, the tribunal has rightly fastened liability against the insurance company which insured the bus, and thus the appeal of the insurance company is not maintainable. Full stop. Next para. It is not in dispute that Exhibit P7 charge sheet was laid against the driver of the bus, holding that due to his negligence, the accident occurred. Full stop. No doubt, the owner of the motorcycle was also charge sheeted as he authorized the claimant to drive the motorcycle, and that the claimant had no valid and effective driving license to drive the said vehicle as on the date of accident, and also that the motorcycle was not insured. Full stop. However, there is no material on record to show that the claimant has contributed for the accident to occur. Full stop. No evidence whatsoever is produced to show that lack of driving skills on his part resulted in the accident to occur. Full stop. Learned counsel Sri Vrishabhendraya failed to bring to the notice of this court any material to show that there was negligence on part of the claimant in riding the motorcycle which is involved in the accident. Full stop. On the other hand, by all the evidence produced, the claimant established that due to the negligence on part of the driver of the bus, the accident occurred. Full stop. Therefore, this court is of the view that the insurance company cannot be exonerated from the liability as prayed for. Full stop. Next. Coming to the amount that is awarded as compensation, the tribunal through the impugned order awarded a sum of rupees 3,45,172 as compensation divided under following heads. A to A. Full stop. When learned counsel Sri T. Vijay Kumar submits that the appellant, the claimant sustained multiple grievous injuries in the accident, and thus the compensation awarded is unjustifiable, Sri H.C. Vrishabhendraya, representing the insurance company, submits that the appellant, the claimant has not produced any evidence to establish the nature of injuries he sustained and the treatment he has taken. Full stop. Admittedly, except examining himself as PW1, the claimant did not choose to examine either the doctor who treated him or any medical expert who exhibited opinion about the nature of injuries that were sustained by the appellant, by the claimant. Full stop. In the absence of any proof, thus, with regard to the alleged disability, this court is of the view that the compensation awarded by the tribunal is highly justifiable. Full stop. Thus, with the foregoing observations, this appeal is disposed of with the following note. Both the appeal stands dismissed without cause.
Amount in deposited.
Amount in
Amount
deposit.
if any in deposit, be transmitted to the concerned tribunal immediately.
Please. Please.
Serial number 56. S. Srinivasaya, D. Vijay Kumar.
I am for the appellant in the connected matter. Ready, my lord. Appeal by the BMTC, my lord.
No representation for other side, Mr. Counsel. No representation on appellant side.
At least they should have informed me that they are ready or not. And they are taken the adjournment.
2023. Full stop.
They don't have courtesy to say, inform me or the court.
Has not filed wakalat for the respondent in this matter. Full stop. Likewise, Sri Srinivasaya A has not filed wakalat for the respondent in the connected.
Since there are only one respondent, my lord, it is both of them have filed appeals.
That
I think it is.
MFA 4330 of 2023. Full stop. Time for 1 week is granted to file wakalats. Full stop. Released on 19th September.
Much obliged.
Serial number 57.
This case,
M.V. Maheshwarappa.
filed a memo for withdrawal.
Respondent is
Dismissed and withdraw.
Three, M.V. Maheshwarappa, Land Counsel for the appellants files memo seeking permission to withdraw the appeal. Permission as prayed for is accorded. Appeal is dismissed, permission seeks permission. A memo to that effect is also filed. Full stop. Permission as prayed for is accorded. Appeal is dismissed as withdrawn.
Serial number 58, adjourn. 59, Gopal Krishnayan. H.S. Lingaraju.
Gopal Krishna Yelmans. Lordship. TC, trial court record is required.
There are two more cases.
All are listed.
In all the cases, Lordship. Connect.
3 cases are listed.
What about notice in the connected matter?
It's what?
Matters.
1645, 59.1 and 59.2.
What about those matters, Mr. Counsel? Notice
Notice over.
Lordship.
to respondent number one.
Notice may be kindly be issued. Lordship.
File memos. We'll pass out the matter, file memos. For that matter, we cannot adjourn.
Please, kindly pass.
59 Passover. 60.
Your Lordship, I am appearing for the appellant.
1 minute,
in
wait.
the
60,000. Number 60, Spurti Hegde for respondent.
In appeal 1613 of 2021, Your Lordship, I am appearing for the appellant. I have challenged, insurance company has challenged the quantum of compensation awarded.
No
The only ground,
representation on respondent side, Amma.
yes, Your
Spurti
Lordship.
Hegde.
Next week it may be.
Srimati Manjula N. Tejasvi, Land Counsel for the appellant in MFA 1613 of 2021, who is appearing for the respondent number one in the connected matter, appears through VC. Full stop. However, there is no representation on the other side in both the appeals. Full stop. Sri Spurti Hegde N is on record. Full stop. To give fair opportunity, list on 18th September.
Obliged, Your Lordship. Your Lordship, may I request the matter either before 18th or after 20th, Your Lordship? There is one trial court matter.
24th September.
Obliged, your lordship.
Serial number 61, Nanjegowda. Deepak BR for R1.
61, I appear for respondent number 1.
In these cases, there are about, I think, 61 ST.
61.8 and 61.9, I am the appellant. But in the remaining 61.1, 2, 3, 4, 5, 6, 7, I am the respondent number 1. And I have not received any instructions from my client. So probably a week's time may be given to see that I will contact my client and get the wakalat filed.
Mr.
I
Counsel,
request
these
for this, my
matters
lords.
are 2021 matters.
Yes, my
Mr.
lords.
Counsel.
I'm not aware of the appellants filing this particular appeal. I'm not being intimated about this. I'm not being served with a copy. I will take instructions from my client and I will collect the copies and file the wakalat, my lords.
Sri Deepak BR appears through VC and seeks time to file wakalats.
He has also filed, he is an appellant in other cases.
For respondent number 1.
Totally, I think, this case.
Total 10 cases.
Mr. Vishwanath had called me today morning. I will take instructions from my client and I will file the wakalats, my lords. 1 week time may be given.
For respondent number 1 in MFA 1866 of 2021 and the connected seven matters.
10 matters.
10, I think.
Point
Total 10, but in
But some appeals he is.
Full stop. The matters are of the year 2021. Full stop. However, to give fair opportunity, a week time is granted. Released on
Yeah. Owner liability.
25th September.
25th.
Much obliged, my lords.
In connecting matters, the lordship may say, those who are not being served the copies, they have to be served.
You get the copies, Mr. Counsel,
I will serve
2021. Now we cannot. Yes.
That's the problem. We have been directed to take notice. Because in some connected cases, we are appealing.
Also served me.
Yes.
I will say.
Serial number 62, Uday Kumar RL. DC Shivanegowda for R2.
Case of death, my lord. The claimants are the brother and sister of the deceased. Last occasion, the Honorable Court told any specific ruling regarding the brothers and sisters are the dependents. In this regard, our own Honorable Coordinate Bench of this court in MFA number. It is there, my lord. 5844 of.
Is it from the Honorable Supreme Court?
My lord, it is orderable. That is in different contestment. The direct brother and sisters are not, it's there. In a many number of other honorable courts, high courts are there. Even divisional bench of this honorable court also.
Take the decision.
What is? Directly, the brothers and sisters in this book, this one. Yes, but very particular leading. Yeah. Citing Birendra and other judgments, my lord. 50%. What is dependency? And it's a 50%. 50%. Here also is a bachelor. 50% only it's come. That is also there. In 2 judgments it is there, my lord.
Mr. Counsel, last time also you submitted these decisions.
No, I am not submitting, my lord. Birendra, the Supreme Court judgments I was submitted. Birendra, last time, this honorable court, very brothers and sisters are there. Major sons and daughters are there.
Where is the judgment?
But I had given it. Last again, this thing, so this Honorable Court told specifically that even in 1987, Gujarat Honorable High Court is very clearly.
Mr. Council, we need the decision
Supreme Court,
from-
is the Supreme Court judgment. Legal heirs, what is the legal heirs? It's very clearly settled, my
Mr.
lord.
Council,
There is-
let your decision be specific.
It is specific only, my lord. In as far as our Honorable Court, single judge and also divisional bench, it's very clear. Brothers and sisters only there also.
Any decision from the Supreme Court? where-
Supreme Court 1987, what is the dependency is very clearly laid down, my lord. 1980,
Where is-
AR 1987, Supreme Court 660. 669, which is and the para, my lord.
Where?
ಈ ಕಾಪಿ
ಯಾರೋ ಹೇಳಿ.
ಅದರಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ. It is settled on, my lord. Dependency, anybody. Even the, if is not a legal heir can also, if he is a dependent, if he established that also, even the legal heirs are entitled for the compensation. Our division bench is very clear. Yes, see. Our honorable divisional bench judgments are there, my lord. It's very straight to the point, my lord. They are also brothers and sisters only. But the judicial discipline, my lord, because already our honorable court has followed it. Therefore, this honorable court also has to be followed, my lord. Even I think there are many number of judgments are there in other honorable courts are held the same. That's right. They are even in the deposition and also very it is clearly stated that the deceased was living with the third respondent, third appellant. He was taking care of the family.
Who are these claimants?
Claimants are the brothers and sisters of the deceased. Sanganathan.
All are separate.
They were all depending upon the earnings of the deceased.
Please, my lord. A third is living with the third claimant. Now she is a respondent here.
What is the evidence you produced that they
And
were,
it is there, my lord. Evidence is there. Please, their deposition prepared.
that they were living together?
And it is there, my lord. Their deposition is there.
Not deposition. Do you have
No,
you
no.
filed any?
Specific document may not be there, my lord.
Issue number one, it is held that, my lord, all are married. They are separately living with their children.
No, that is not the issue, my lord. Here the third appellant is living with the deceased. More than they are all the legal heirs, my lord. Legal heirs order section 11, 211 is very clearly held. In many number of judgment is there. That is the case, my lord. See, even Indian Succession Act, Christians, as per the section 47 and 48, see, all brothers and sisters are equally entitled for the estate of the deceased. That is the law, my lords. Even on that grounds also, they are entitled for this one. In 1960 itself, it is a judicial discipline. There should be followed. A coordinate bench or the judicial bench of the order should be followed until it is not distinguished separately. That is the law, my lords. Many number of judgments like that. And Article 141 clearly says here, divisional bench clearly held. Brothers and sisters are the dependents are legal heir. They are entitled for the claim compensation. In the division, our single bench also coordinate bench has held in the same way. If specifically I want, I have to make a research and make a as far as the dependency. So settle now, my lord, because if it goes for any other number of Allahabad judgments or even Bombay judgment are declared. Now the ACJs are reported, but this honorable court specifically asked for the Supreme Court. Our own honorable High Court divisional bench also coordinate bench has clearly held that brothers and sisters are entitled for regulation. On 1987, state of Gujarat versus this one, that is very clearly. That is the limit. Subsequently, in all the judgment that is mentioned. Yeah, 2019-60 Supreme Court, 19th Honorable Court very clearly, whatever that coordinate bench and that has to be followed. But all, if you want to district, they should refer to the higher larger. That is what the Honorable Supreme Court. Subsequently, in 2008 also that is repeated. So even very recently in criminal appeal also, it is also stating this one is very held. Because judicial discipline is required. In this case, even divisional bench has very clearly. Brothers and sisters only.
Yes, Mr. Counsel.
Please, Lord, in this case, what he says that the relying upon the apex court state that the other coordinate bench has taken the decision, therefore that is not the facts of the case, whether it is same or remains same or the different, that has to be looked into. All these document what the decision which is quoted, it is not similar to the case which is now before your lordship. Here is the case, my lord. Some of them are brothers and some of them are not established to prove that they are the brothers of the deceased. The other fact, my lord, the document what they got produced before the court does indicate they are living separately. It is not with them. Therefore, my lord, court has considered in this aspect while granting the compensation, and hence, my lord, they are entitled to get the, if at all this court comes to conclusion, they are entitled to get the loss of estate. What extent of the loss of estate has to be taken? In the division bench of Disamba court has held that in Manavalagan case, where, my lord, the 50% or 15% of the income of the deceased has to be taken as a loss to the estate. To that extent, my lord,
Another place was referred in single judge, my lord. That there it is very wife and husband. The wife is living in Madras. He is also earning member. He is no way dependent. That is extraordinary. That is not the case. It's very recent judgment, my lord. After that, this judgment.
Where are those
Any
judgments?
specific one, I will produce any. I will
Finish,
research and it is this Karen 19, my lord. Very clearly held, my lord. It is the duty of the. One dependent are there, he is entitled only for 50%. He is a bachelor. Any number of dependents may not be have any effect on the compensation. On dependency. Even if one dependent is there, he is living with that is there, evidence are there.
So we'll deduct 50%.
Please, madam, that is there, madam, because the batch.
There is Supreme Court judgment on that issue, my lord. Dinesh Jain versus New India Assurance Company. Straight on that point, 50% has to be deducted. Only question, in this case, what I am raising before your lordship, they are not depending, they are separately living. Therefore, my lord, considering this view, the loss of estate has to be reduced. That's what. Otherwise, there is a straight point on that issue, my lord.
Loss of estate only 15,000 was granted.
That is correct.
Loss of estate.
That is
in the
correct,
sense of
madam.
the estate, madam. Deceased estate.
No.
That in that context.
What my submission, my lord, they are not entitled to get the loss of dependency. They are entitled to get only the loss of estate. A loss of estate, what is he has saved in his life, that is the loss of estate. So, my lord, the Supreme Court has taken in one matter, my lord, 50% has deducted. Some of the court of Disaba court is also taken 50% to that extent. What my respect submission in those cases, my lord, they are residing in a same house, but here is the case, my lord, we have elicited and produced a document to prove that, my lord, they are living there with their family in a different houses, and the document were placed before the court. Therefore, my respect submission that loss of estate has to be, instead of 50%, it has to be reduced. That
is not, as far as the deceased, my lord, he is living with the third claimant, and that is the evidence is there. Even they are elicited.
64 years.
64 years.
According.
7 will be the multiplier. 50% that is deducted. Since he is a bachelor, any number of dependents are there, that is not the issue here. 50% plus loss of estate and consumption.
Then at this age, can he?
That is the settled law, my lord.
Earn the money as the young man earning. That is also notional income.
Even
it's only a guest work has to be taken, my lord, notional income, because he is 64 years. Can he discharge work?
That is a painter. That is all the evidence. That is not the issue, madam. That is already said in many number of judgments. It is there. The income, what is the, since there is, he has not proved the income as per the Adalat chart is there. It is there. It is a 2020 or 15,000.
Adalat chart be followed for a 20 years man and
that's
60 years man.
No, my lord. That is, this is, 64 years means that is the income. He is a painter, man. Now see up to 70, 75 people will earn, my lord. They have to earn it. That is not the, that is the, in all cases it is followed, my lord. So the income is taken as per the other. There is otherwise it can't be established, my lord. Even he may tell us 25,000, that may not be there. Is a painter, what records or document can be produced? That is all settled, my lord. That is a many number of varied example court and Supreme Courts are clearly held in that. That is not the issue. The beneficial legislation, my lord, very liberally construed, my lord. That all the judgments are interpreted. 15,000 should be taken, my lord. 7 is the multiplier. Half of the income is full.
64 years.
64 years.
7 is the appropriate.
Please, my lord. 7 is the multiplier. That is all not disputed, my lord. That is all settled, my lord.
We have taken the notional income as rupees 10,000.
No, 10,000 less, my lord. It is there, my lord. No, please, that is problem. He is a
Adopted
painter, my lord.
multiplier
If goes
7.
by the evidence, he is earning 25,000, that is there. No, please, my lord.
That's 40,000 towards loss of estate.
No, lot of estate, they are all this 30,000 rupees lot of estate, but after Pranay Sethi, the 6 years, even 20% income, this increment should be taken because of this one. That is the 10%. 20% because 10 that every 3 years 10% should be increased. That is also there, my lord. At least 10% all honorable courts are taking, even Supreme Courts are held. Even for that also there are judgments, my lord.
Not dependency. This is.
No, dependency, my lord, is dependent. It is there. Dependency is not the issue, my lord. As far as they are, section 211 is very clearly, it is what in Birendra and many number of cases development. That is not the issue, my lord. Even our, what I cited, this honorable court, coordinate bench, single bench, and also divisional bench is very clearly.
Mr. Counsel, loss of estate is 8 lakhs.
No, my lord, even if that, as far as this one is, my lord.
Expenses 16,500.
No, my lord, that is not correct, my lord. That may not be.
Mr. Counsel, we will not entertain such a submission.
Please, my lord, because
Yes. If you want to challenge the order, you can challenge before the.
That is not, my lord, please, my lord, that is not issue, my lord, please.
Heard.
No, my lord, please, but there.
You are Mr. Uday Kumar.
Please, my lord.
Heard Sri Uday Kumar RL, learned counsel for the appellants, as well as Sri BC Shivanagoda, learned counsel who represents respondent number 2 insurance company. Challenge in this appeal is the order that is rendered by the Motor Accidents Claims Tribunal Bangalore in MVC 1145 of 2020, dated 25/2/2021. Full stop. The appellants projecting to be the dependents of the deceased Saganathan, within brackets hereinafter be referred to as the deceased for brevity, moved an application claiming compensation of rupees 20 lakhs in total. Full stop. Exhibiting its view that the appellants cannot be termed to be the dependents of the deceased, the tribunal awarded a sum of rupees 15,000 towards loss of estate and rupees 15,000 towards funeral and conveyance expenses. Full stop. In total, the tribunal awarded a sum of rupees 30,000 as compensation. Full stop. Next, arguing the matter, learned counsel Sri Uday Kumar RL submits that the appellants are the siblings of the deceased. Full stop. They were all depending upon the earnings of the deceased by the date of accident. Full stop. The deceased, as a painter, was earning rupees 25,000 per month, and he was contributing his earnings, entire earnings, towards the welfare of the appellants. Full stop. Without observing these factors, the tribunal did not award any amount under the head loss of dependency, which is unjustifiable. Full stop. Learned counsel thereby seeks to award the amount claimed as compensation. Next, vehemently opposing the submission thus made, Sri BC Shivanagoda, learned counsel for respondent number 2, contends that the points elicited during the course of cross-examination of PW1 themselves speaks that the appellants were not depending upon the earnings of
It is there in the record. They are instead.
Mr. Counsel, please be quiet.
I agree with that.
Due respect, please be quiet. What did you write? We have patiently heard your entire arguments. Now you are not required to disturb it. Yes, what did you write? Earnings of the deceased. Full stop. All the appellants got married and were maintaining their own family members. Full stop. Thus being the situation, they cannot be termed to be the dependents of the deceased. Full stop. Learned counsel brought to the notice of this court the discussion that went on in issue number 1 in the impugned order. Full stop. Next, there is no denial of the fact that the observations made by the tribunal at para 9 of the impugned order is as under. My A to A. Full stop. Thus, thus it is clear that The first appellant got married, begot one child, got married and begot one child. Full stop. The second appellant got married, comma, has begot 3 children and is residing at her matrimonial home. Full stop. The third appellant got married and begot a child. However, her husband is no more. Full stop. The fourth appellant has got 2 children. Full stop. The fifth appellant got married and begot 3 children. 3 children. Full stop. The sixth appellant is married and got 1 child. Full stop. Admittedly, no proof is produced to show that the appellants were residing with the deceased by the date of accident. Full stop. However, projecting that even the brothers and sisters are entitled for compensation, Land Council relies upon the decision of the Honorable Apex Court in the case between Gujarat State Road Transport Corporation versus Raman Bai, Prabhat Bai and another, reported in AR 1987 Supreme Court 1690. Stop. In the said decision, the Honorable Apex Court at para 11 of the order para 11 of the judgment held as follows: B to B. B. Good stop. The aforementioned decision makes it clear that every legal representative who suffers on account of death of a person due to a motor vehicle accident is entitled for compensation. Full stop. Therefore, it is incumbent on part of the appellants herein to show that they suffered on account of the death of the deceased, full stop. The said sufferance financially should be established by producing cogent and convincing evidence to the effect that the deceased was at any time contributing for the welfare of the appellants, contributing any amount from his earnings towards the welfare of the appellants. Full stop. Next page. Also contending that in the similar circumstances, this court awarded substantial sum towards loss of estate. Land Council also relied upon the decision of the division bench of this court in the case between B.V. Gopala and another Mehboob Pasha and others in MFA 7318 of 2016, dated 23/10/2022. In the said decision, the court at paras 10 to 14 held as follows, C to C. Learned counsel also relies upon the coordinate bench, the decision of the coordinate bench of this court in MFA 5319 of 2022 dated 16 July 2024 at paras 24 and 25 of the judgment held as follows, D to D. In the case on hand, no material is produced to show that the appellants were depending upon the earnings of the deceased. Full stop. At the same time, there is no denial of the fact that the deceased remained unmarried. Unmarried.
Is it back?
And that the appellants are the siblings of the deceased. Full stop. Therefore, this court is of the view that 50% of the earnings of the deceased are required to be deducted towards his personal and living expenses, and thus on calculating the compensation, the amount the amount arrived at is required to be awarded under the head loss of estate. Full stop. Admittedly, next paragraph, the deceased was aged about 64 years by the date of accident. Full stop. The contention of the appellants is that the deceased as painter was earning rupees 25,000 per month. Full stop. No proof is produced either in respect of the occupation or the earnings of the deceased by the date of accident. Full stop. The submission that is made by learned counsel for respondent number 2, Sri B.C. Shivanagowda, in this regard is that the deceased, who was aged about 64 years, cannot be expected to do painting work, and indeed the deceased was not earning anything by the date of accident. Full stop. It is not a case that the deceased was suffering with any kind of ailment or was depending upon others by the date of accident. Full stop. However, considering the fact that there is no convincing proof with regard to the actual occupation and earnings of the deceased by the date of accident, for the purpose of calculating compensation, this court considers desirable to take the notional income of the deceased as rupees 10,000 per month. Full stop. The appropriate multiplier to be applied as per the decision of the Honorable Apex Court in Sarla Verma's case is 7. Full stop. Thus, the loss of estate, if calculated, on the loss of the amount which the appellants are entitled to towards loss of estate is as under. Tabular form: notional monthly income 10,000, annual income 1,20,000. On applying appropriate multiplier 7, 8,40,000. Full stop. Next, together with the thus the appellants are entitled to rupees 8,40,000 towards loss of estate. Full stop. Together with the said amount, the appellants are entitled to rupees 16,500 towards funeral expenses. Full stop. Thus, the total compensation which the appellants are entitled to is 8,56,500. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MBC 1145 of 2020, dated 25/2/2021, is enhanced from rupees 30,000 to 8,56,500. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop. Out of the enhanced sum, all the appellants are entitled to equal share. Full stop. The appellants are permitted to withdraw their respective shares on deposit.
Right.
Three nine double three of 20. This is 3933 of 2020.
Serial number 64, madam.
1 minute, please. Yes, Mr. Counsel.
64, my lord.
Appear for responding.
Weak, my lord, both of them. I have took it into the lower court records, sir. TCR is received, my lord. I have to see.
PCR received it.
Yes, madam.
64.
Received. Yes, we'll see after.
Next week, man.
Next week, my lord.
Next week. At request of Sri Janardhan Reddy, Land Counsel for the appellant, and Sri
Shyam Prasad,
Shyam Prasad, Land Counsel who represents
claimant respondent.
Sri Paramesha KL, Land Counsel on record for respondent number
1 and 2.
1 and
1 and 2.
One.
Respondent number 1, comma, list the matter on 12th September.
69.
69.
I forwarded the appeal memo to the company.
69 already
Refer to
adjourned.
Lok Adalat. Refer to Lok Adalat.
ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಮೇಡಮ್ 56 ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಮೇಡಮ್ 56
Pass over matter, serial number 16. FS Dabali, Sripad V Shastri are responding.
No representation on either side on call. Yes, Mr. Shastri. No representation. FS Dabali is not available.
Well, it is only a calculation. It is only calculation.
What to do? Other side is not there.
At least my IA may be considered because they are deposited the award amount, and I have already permitted to.
Yes, Mr. Council, Land Council Dabali has come.
Yes. But it is only a calculation, my lord. Their appeal is required to be allowed, and my appeal is also required to be considered.
Mr.
My lord,
You have also filed appeal disputing the quantum, huh?
A negligence one because he was a pedestrian.
Hence also, okay.
The accident took place not in early morning in Kapun Road, not exhibit P4 blood is the sketch. P4 blood. P5 blood.
These claimants are
The mother and brother blood.
mother and brother.
Brother, the bachelor, 50% is required.
This was a bachelor. There is no dispute blood, 50% has to be directed towards personal expenses.
Yes. That is the mistake, my lord. 2/3 is that is the major issue.
But here, not future prospects has not been taken.
But may I submit, my lord?
One minute, Mr.
Okay.
So age is not in dispute, 30
Not
years.
in dispute, not in
30
dispute.
years.
17 is the multiplier properly adopted.
So he died as bachelor, huh?
Yes, my bachelor. Tribunal by mistake consider mother as a wife. That is why this mistake happened. But if 40% is added, my lord, to 15,000 per month as mentioned in the Loka chart, it comes to 10,500. If 21,000.
Mr. Shastri.
Yes, my lord.
You make your submission with regard to the merits of the pattern, calculation will make.
Yes.
Yes, what is your contention?
My lord, 40% is to be added. That is not added. If to 15,000, if 40% is added, it comes to 21,000.
Mr. Counsel, any further submission on the merits?
That is only as far as the negligence aspect is concerned, my lord, page number, para number 13 end. The tribunal para number 13 end. Front right bumper dented and scratched. That is the observation of the tribunal. So as far as negligence aspect is concerned, my lord, I don't think my learned friend has any case.
Yes.
So if 15,000 as mentioned in the Loka chart is considered, 40% is added.
Yes, Mr. Counsel, calculation will make. Yes. Yes, Mr. Dabali. any
About
further
conventional
supplement?
heads, not only mother is entitled for loss of consortium 40,000.
Yes.
Yes, my lord. Yes, yes, I do admit, my lord.
About quantum at 25,000, which has been paid by the corporation has not been deducted. That has to be deducted.
Huh? Huh?
25,000 as interim
Yes, yes,
compensation was paid.
We'll do it.
It is not interim, it is ex gratia payment.
About quantum, it comes from the loss of dependency. 21,42,000. Well, not 40,000 and consortium and visual expenses. Estate.
The notional monthly income is taken as 15,000.
15,000.
40% is added towards future prospects, deducted 50% towards personal expenses, applied multiplier 17. It comes to rupees 21 lakhs 42,000.
Yes, ma'am.
So the funeral expenses is 16,500. Loss of estate is 16,500. Loss of filial consortium 44,000. So the total comes to rupees 22 lakhs 19,000.
19. Out of that, but 25,000 interim compensation has been paid.
No, it is not interim.
No. Exhibit R3 is not the receipt which we have produced.
No, it is a ex gratia
No.
payment. It is ex gratia payment, not interim.
No.
No,
Exhibit
it is
R3
not
was
interim.
produced. It states interim compensation.
No, it is it is to be called as before this one filing of the petition immediately after the accident. That this ex gratia payment is paid. In the strict sense, it cannot be deducted. Anyway,
that trouble has not deducted that amount. Exhibit R3 was produced, not the receipt. Even the claimant has admitted about the receipt.
yes. I am admitting. I am not disputing. So the amount almost
It comes
equal.
from 21 lakh 94,000. It comes from after deducting 25,000.
How much you paid towards interim?
25,000, my lord.
25.
Exhibit R3 was produced by the interim compensation, which has been admitted.
No, it is not interim. Repeatedly, I am telling.
No, you may say so many things, but it is an interim.
No, it is ex gratia payment. If it is interim compensation, my lord, it is required to be deducted. I am not disputing. It is left to the court. Definitely it is left to the court. But the law says, my lord, ex gratia payment is only immediately after the accident. My lord, there is a fund is created. It is not as of compensation. It is ex gratia payment.
So this is 21 lakhs 94,000.
Yes, ma'am, 21 lakh 94,000. Then, murder about negligence on the part of the claimant. The accident took place in the early morning at about 6:30 a.m. on the Kappan Road. Exhibit P5 is the sketch. Because it is almost murder.
Who is RW1?
The driver.
The mother, my lord.
Huh?
RW1 is the driver.
RW1 is the driver.
RW is driver, my lord.
Did RW1 made any attempt to dispute the contents of the charge sheet?
He has
No, ma'am.
not disputed,
No.
but manner of accident, but mere filing of charge sheet, my lord, it is not conclusive evidence.
But what is the evidence you produced to show that
Exhibit
this is
No independent evidence is produced.
P5, my lord, is a sketch murder. P5 is a sketch, my lord, sketch.
sketch cannot describe that the deceased was negligent.
About manner of accident, my lord.
No, Mr. Counsel. Yes. Heard. When it was in June.
Because it was a road murder, main road, where he suddenly crossed murder the main road, where there is no pedestrian crossing in the early morning. In that, my lord,
Heard. Sri F.S. Dabali, Land Counsel for the Appellant in MFA 3982 of 2023, who is also appearing for the respondent in the connected appeal, that is MFA 3983 of 2023. Mr. Land Counsel appears physically before this court and argues. Full stop. Also heard Sri Shripad V. Shastri, Land Counsel for the respondents 1 and 2, and counsel for the respondents in MFA 3982 of 2023, who is appearing for the appellants in MFA 3983 of 2023. Land Counsel Shripad V. Shastri appears through VC. Next. The order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MBC 5160 of 2021, dated 30/12/2022, has resulted in these two appeals. Full stop. The parties to the appeals will hereinafter be referred to as the corporation and claimants for the sake of convenience of discussion. While the corporation disputes its liability to pay compensation, the appellant is the claimants are before this court seeking enhancement of compensation as against the claim for rupees
50 lakhs.
50 lakhs, the tribunal through the impugned order awarded a sum of rupees 22 lakhs 15,000 as compensation. Full stop. Next. Arguing in respect of merits of the matter, Sri F.S. Dabali, representing the corporation, contends that the deceased Gopi was negligent while crossing the road, and due to his negligence, the accident occurred. Full stop. The driver of the corporation was not at fault, but the tribunal fastened liability against the corporation. Full stop. Land Counsel states that Exhibit P5 sketch speaks about the manner of happening of accident, and thus considering the said document, the Appeal filed by the corporation is required to be allowed. Full stop. Next paragraph. Opposing the submission thus made, Sri Shripad V. Shastri, Land Counsel for the claimants contends that the accident occurred due to the rash and negligent driving of the driver of the corporation. Full stop. The deceased Gopi died when he was hit by the bus of the corporation. Full stop. Even after investigation, charge sheet is laid against the driver of the corporation. Full stop. Thus, the tribunal rightly fastened liability against the corporation, and therefore the appeal filed by the corporation is unsustainable. Full stop. Next. The manner of happening of accident as projected by the claimants before the tribunal is that on 3/9/2021 at about 6:30 p.m. while the deceased Gopi.
That 6:30 a.m.
6:30
a.m. a.m. in morning.
At about 6:30 a.m. while the deceased, this is mentioned as 6:30 p.m. only, even in the issues, Mr. Counsel.
Death of Gopi, yes.
Even in the issues, it is mentioned as.
But it is
6:30
wrongly
PM.
mentioned, but in the FIR and charge sheet, but 6:30 a.m.
Record has.
Yes. P1 FIR.
At about 6:30 a.m. Mr. Counsel, even in your pleadings, you have mentioned that it is at 6:30 p.m.
But as per FIR and charge sheet, 6:30 a.m. in morning.
What did you write? On? You remove that. You remove that. On 3/9/2021, while the deceased Gopi was proceeding on road as pedestrian, and while he was crossing the road near Main Guard Junction, Kabban Road, Bangalore, the driver of the corporation bus bearing registration number KA42F1691 came at a high speed, driving the bus in a rash and negligent manner, and dashed against the deceased Gopi, due to which he sustained grievous injuries on vital parts of the body and succumbed to injuries. Exhibit P2 complaint formed basis for the police to register the case and investigate into. Full stop. Charge sheet was laid against the driver of the corporation, duly observing that due to the rash and negligent driving of the driver of the corporation, the accident occurred. Full stop. This is evidence by the contents of Exhibit P3 charge sheet. Full stop. This is not a case of res ipsa loquitur. Full stop. Exhibit P5 sketch alone cannot establish the manner of happening of accident. Full stop. No convincing evidence is produced by the corporation to establish that the deceased Gopi was at fault. Full stop. Considering the evidence that is produced in toto, the tribunal came to a conclusion that the claimant succeeded in establishing that the deceased died due to the rash and negligent driving of the driver of the corporation. Full stop. Thus, this court does not find any grounds to interfere with the findings given by the tribunal in that regard. Next paragraph. It is not in dispute that the deceased Gopi died as bachelor. Full stop. Therefore, as rightly submitted by Sri Shripad V. Shastri, Land Counsel for the claimants, the tribunal ought to have deducted 50% of the earnings towards the personal and living expenses which the deceased would have incurred for himself had he been alive. Full stop. But the tribunal deducted 1/3 of the earnings, which is improper. Full stop. Next paragraph. The claimants are the mother and brother of the deceased Gopi. Full stop. Their version is that as mason, the deceased was earning rupees 15,000 per month. Full stop. However, per month. Full stop. As rightly contended by Sri F.S. Dabali, no proof is produced by the claimants to establish the occupation and earnings of the deceased Gopi by the date of accident. Full stop. The submission that is made by Sri Shripad V. Shastri in this regard is that the accident occurred in the year 2021 and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 15,000 per month, and therefore the said figure is required to be applied. Full stop. Sri F.S. Dabali, Land Counsel for the corporation, did not raise any objection to take the notional income as rupees 15,000 per month as sought for by the Land Counsel for claimants. Full stop. Next one. Claimants. Full stop. Therefore, the notional income of the deceased 20,000 per month. That what did you write? Mason. You have write Mason. That 20,000. Yeah, there only 20,000. Don't change ADR. This is 15,000 only. Yes. Therefore, this court considers desirable to take the notional income of the deceased as rupees 15,000 per month. Next. Admittedly, the deceased Gopi died at the age of 30 years. Full stop. Therefore, 40% of the earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. The appropriate multiplier to be applied is 17 as per the decision of the Honorable Apex Court in Sarla Varma's case. Rightful citation. Full stop. Thus, the compensation which the claimants are entitled to under the head loss of dependency is as under. Notional monthly income 15,000. Annual income 1,80,000. Add 40% towards future prospects 2,50,000. Deduct 50% towards personal and living expenses 1,26,000. Loss of dependency on applying appropriate multiplier 17. 21,42,000. Next. Thus, the loss of dependency. Thus, the compensation which the appellant, the claimants are entitled to under the head loss of dependency is 21,42,000. Full stop. Together with the said amount, the claimants are entitled to rupees 16,500 towards funeral expenses, 16,500 towards loss of estate, and rupees 40. Full stop. The first claimant, being the mother of the deceased, is entitled to rupees 44,000 towards loss of filial consumption. Full stop. Thus, the total compensation which the claimants are entitled to is as under. Loss of dependency 21,42,000. Funeral expenses 16,500. Loss of estate 16,500. Loss of filial consortium 44,000. Total 22,19,000. Full stop. Next, Learned Counsel Sri F.S. Dabali submits that a sum of rupees 25,000 was paid to the claimants towards interim compensation, and Exhibit R3 to that effect is also produced. Full stop. Learned Counsel Shripad V. Shastri did not deny the said payment. Full stop. Therefore, out of the total compensation granted, a sum of rupees 25,000 is required to be deducted. Full stop. Thus, the compensation which the appellants are entitled, the claimants are entitled to is 21,94,000 within brackets 22,19,000 minus 25,000. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 22,15,000 as compensation. Full stop. However, the justifiable sum which the appellants, the claimants are entitled to is 21,94,000. Full stop. Therefore, both the appeals are disposed of with the following order. MFA 3982 of 2023 is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, in MBC through orders in MBC 5160 of 2021 dated 30/12/2022 is reduced from 22,15,000 to 21,94,000. The award of the tribunal in all other aspects holds good.
The amount,
Appeal
the amount,
in MFA 3983 of 2023 stands dismissed without cause. Full stop. Amount, if any, in deposit be transmitted to the concerned tribunal along with the relevant record immediately.
My lord, may I make one submission, my lord? The records may be sent forthwith, my lord.
That becomes infructuous. Pending interlocutory applications, if any, stands closed. Yes, Mr. Counsel.
That records may be sent forthwith, my lord.
We are sending the records also. Yes. A time for a week is granted to Sri F.S. Dabali to file wakalat in MFA 3983 of 2023.
Serial number 49. Passover matter.
Yes, I agree for this. One matter.
Respondent claimant.
Gopala Krishnayan.
Respondent number
I'm
124.
finding a dispensation memo to the owner of the vehicle since he placed ex parte before the court.
Sri P.C. Shivanagoda.
He placed ex parte before the court below, my lord. Therefore, though I am challenging the liability, he placed ex parte before the court below. Therefore, notice to R1, R5 may be dismissed.
Where is that appeal?
1091 of 23, my lord.
1090.
R5.
You are disputing your liability.
I am disputing liability.
If you are disputing your liability, the liability should go to the fifth respondent.
Please, notice was served to him before the MSCT, where my lord he placed ex parte. He has not contested the matter. Therefore, on that ground, I am dispensing the notice. He is aware of that pendency of the. Otherwise, a week's time may be granted. I will take steps.
Learned Counsel Sri B.C. Shivanagoda seeks a week time to furnish the requisites. Time as prayed for is granted. On furnishing the requisites, office to send notice to Respondent number 5 in MFA 1091 of 2023.
Much.
Full stop. List both the appeals on 12th November.
Much.
Serial number 59, passover matter.
For the
Gopal
appellant
Krishna.
represent Gopal Krishna.
Just Lingaraju.
Krishna Bhatt. The notice to the respondent number 1 kindly be dispensed in both the cases, my lord.
59.
59.
Notice may be kindly dispensed for the respondent number 1, my lord. You have for substitutions of insurance policy. The liability was submitted by the respondent number 2, my lord.
Separate memos in MFA in MFA 1645 of 2024 and 1860 of 2024 are filed seeking the court to dispense notice to respondent number 1 in both the appeals. Where are the records? 1645.
R1 is the Cholamandalam General Insurance Company. R2 sorry, Milash. Respondent number.
That matter? So in the other matter for Cholamandalam General Insurance, HS Lingaraj is appearing.
Please, Milash. HS Lingaraj is there. Already filed on Wakala. Filed. HS Lingaraj.
Why his name is printed? As Sri H.S. Lingaraj was called upon to accept notice for respondent number 2 in the connected appeal, that is in MFA 1714 of 2021, full stop, comma, the same counsel is called upon to accept notice for respondent number 2 in MFA 16145 of 2024 and MFA 1860 of 2024 also, full stop. Also subject to the endorsement of the cases otherwise by respondent number 2. Wakalats to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of dispense with done now. File separate memo seeking dispensation of notice. Thereafter, there you write. Full stop. Land Counsel Sri T. Vijay Kumar representing Sri Gopal Krishna N submits that as respondent number 2 admitted his liability, comma, notice to respondent number 1 in both the appeals be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 in both the appeals stands dispensed with, however, at the risk of the respective appellants. Next one, here to call upon to appellants to serve copies of appeal papers at the chambers of Sri H.S. Lingaraj. List on 511.
Please, Milash.
Serial number 65. BC Sitaram Rao. Serial number 65. Respondent served under.
No representation on appellant side on call. Where is the proceeding? To give fair opportunity, list on 16th October. 23rd October, 23rd.
Serial number 66, Satisha T. AM Venkatesh.
I am for R2, my lord. Claim petition is dismissed on merits. Therefore, records may be called for, my lord.
Records received. No representation on appellant side on call. To give fair opportunity, list on 23rd October.
Serial number 67, Ravi Shankar Shastri, SV Hegade Malkund for
Respondent for the appellant, my lord. My lord, I am seeking enhancement of the compensation. My lord,
Wakalat has been already filed today.
my lord, the date of accident is 11/6/2017, my lord. There was a fracture of right radius, my lord. And he was inpatient for a period of 4 days in the hospital. My lord, doctor was not examined. My lord, the out of 27,967 was the medical bills, my lord. MACT has awarded 50,000 as compensation, my lord, without determining under the various heads. Para 11 is the only, my lord, reasoning portion regarding quantum of compensation. MACT holds, my lord, I have not examined the doctor, and medical bills is itself is 27,967, and thus, my lord, awards global compensation of 50,000. My lord, I am seeking enhancement on this, my lord. My lord, exhibit P9 is the discharge summary, my lord. It speaks that, my lord, there was a right distal radius fracture, and he was inpatient for a period of 4 days. The claimed income was, my lord, 25,000 by working as a waiter in Rama restaurant. My lord, no evidence was tendered to prove the evocation or income. My lord, therefore, my lord, considering this aspect, my lord, MACT ought to have awarded, my lord, under different set, my lord, pain and agony, then, my lord, loss of.
What can the, why you have not examined the doctor?
So doctor was not examined. There was a fact remains, my lord, there was a fracture of right radius. My lord, he was a waiter. My lord, under head of pain and suffering and loss of income during later period and loss of amenities.
Regarding this occupation, they not examined anybody. Regarding injury sustained and disability, they have not examined the doctor. What he has produced is the discharge summary and inpatient bill. So considering that, my lord, in the facts and circumstances, my lord, the tribunal has granted reasonable compensation. 50,000 rupees has been granted. And that, if your lordship pleases, and that 10 to 15,000 may be added to that.
My counterpart should be reasonable, my lord. In the Appellate, they offered 50,000 with the interest.
No, Adalat, my lord, whatever we are saying, it is not applicable here.
My lord, ultimately, my lord,
Because-
man, my lord.
Lokadalat, you agreed for 50,000.
We have not agreed anything, my lord.
My lord, they offered, my lord, but my client, my lord, said he.
Why you did not accept?
My lord,
They want 1,20,000 like that.
my lord, the right radius fracture, my lord. He cannot
Any-
work, my lord, as a waiter for.
We'll refer the matter to Lokadalat. You
It
accept
can be, my lord, it will not be.
enhancement. You accept for 50,000 enhancement.
Again, my lord, this again, my lord, matter can be once for all disposed of, because I think a trial court records regarding the discharge summary is there. Again, my lord, it is last time in length it was discussed.
50,000?
I will leave it
50,000 with interest, my lord, last.
with interest global, my lord, because
ಅಲ್ಲೇ offer ಮಾಡಿದಿರಲ್ಲ 50,000 with interest.
again, my lord, I am.
Since my client did not agree, my lord, I have requested to place before the honorable court. My lord, my lord,
Global, it was agreed.
if my lord calculates under pain and suffering, my lord, minimum 20,000 for a fracture, my lord. Laid up period, another 20,000. If my lord feels, my lord, it would be 40. Amenities, if 10,000 is awarded, 50,000 it will.
My lord, even if
Enhancement will be only 25,000.
No, my lord. My lord, so far as the MACT is concerned, a medical bill itself is 27,000. my lord.
Yes, 50,000 globally.
50,000 already granted.
Another 50,000.
I'll leave it to your lordship, my lord. Let it be your lordship's order, my lord. Because it has come back from Lok Adalat.
Even in the order, we have to justify.
My lord, exhibit
But,
P9 discharge.
Only,
summary,
my lord, the
speaks.
discharge summary, your lords.
Injuries are there, inpatient for 4 days. Then my lord, there was insertion of, my lord, a rod to the right hand.
What evidence is there that there is insertion of rod? How
Exhibit
can
P,
we presume?
P9.
What is the evidence you produce to prove the genuineness of exhibit P9?
Otherwise, your lordship may kindly say, taking into consideration facts and circumstances. My lord, additional 20,000 for pain and suffering, and that 10,000 rupees for this.
Then it would be only 30,000.
Laid up
What,
period.
50,000, my lord?
Laid up period, my lord, it comes. Right hand fracture.
Yeah, we
Right.
agree. 17 means, my lord, even if 40,000 is awarded, he will get the same amount. Interest also he will get. For a period of nearly, my lord, 7 years. 40,000 you will not like percent. ಎಷ್ಟಾಗತ್ತೆ ನೋಡ್ರಿ 50 ಅಂದ್ರೆ ಅಲ್ಲ 40 ಅಂದ್ರೆ $42,000.
For a single injury, even if it is pain and suffering, 30,000. Transportation, extra nourishment, diet and charges, 5,000. Loss of earnings during laid up period, 20,000. It comes to rupees 55,000.
Then medical expenses, my lord, 20.
Medical expenses, total it comes to 75,000.
Yes.
So it means deducting this
There is evidence that, my lord, he requests future medical expense of 25,000. Insertion was there, my lord. Therefore, my lord,
Mr. Counsel, granting medical expenses of 27,967 without any proof itself is not proper.
medical bills were there.
We'll refer the matter to Lok Adalat settle.
my lord, already, my lord, it's failed there.
Huh?
It's failed. And his party didn't agree.
They offered, my lord, 50.
Now they will agree for 50,000. Now that they'll agree for 50,000.
Otherwise, my lord, your lordship may by consent, looking into the nature of injuries.
Mr. Counsel, our orders should be consistent.
Correct, my lord, yeah.
For the matter,
How in
Adalat,
this
my lord.
matter?
Yes, my lord, I'll leave it to your lordship.
Because Mr. Counsel, if I say that you have agreed for 50,000, you will not agree to record it in the order.
Yes.
If
Lordship
you
may
agree
refer the
that
matter.
both the parties agreed for 50,000,
It
we'll,
may be referred to Lok Adalat.
Adalat, lordship. Please.
at request of Land Council for the appellant, we have no objection for granting 50,000. Because if we grant
Correct.
it at such
Lordship may refer the matter.
tomorrow, my own order will be released before me. and state
Correct.
That in that order
Correct.
you have granted so and so. At
Correct.
request of Sri Ravi Shankar Sastry, Land Council for the appellant, as well as Sri S.V. Hegde Mulkund, Land Council for respondent number 3, the matter is referred to Lok Adalat for settlement.
Serial number 68, Vijay Kumar T, B.A. Ramakrishna for R1.
Okay, for the appellant, my lordship.
Yes,
Respondent.
Claimant appeal for enhancement.
yes.
My lordship, the date of accident is 11/3/2019.
Hmm.
The injury is, my lordship, fracture of both bones of left leg.
Hmm.
The doctor assessed 40% functional disability to the particular portion of the body, my lordship. The tribunal taken only 13% to the whole body, my lordship. And my lordship, I have taken treatment for a period of
20 days.
20 days, my lordship. The income, my lordship, rightly taken as per the Karnataka Legal Service Authority, my lordship, 14,000. Lordship, as per the doctor evidence, my lordship, surgical operation was conducted to tibia bone of left side leg by fixing implants, my lordship.
The compensation awarded under the head of pain and suffering and amenities is very meager, my lordship. 40,000 under the head of pain and suffering and 20,000 under the head of amenities, my lordship. And towards laid up period, my lordship, only
2 months.
2 months, only 2 months was awarded, my lordship. Like considering the nature of injury, fractures and disability, my lordship, the award amount is very meager, my lordship. And the doctor deposed that, my lordship, 35,000 to 40,000 is required for future medical expenses, but the tribunal committed an error awarding only 10,000, my lordship.
It's only removal.
Kindly see the page number 24, para 33, my lordship.
So how much can be increased globally?
My lordship, compensation towards the loss of future prospects kindly be awarded, my lordship, considering the nature of fractures and disability.
It is 13% for the whole body. Future prospects is not attracted.
Disability is 13%.
13%.
13% taken by the tribunal.
That is
But,
1/3 of the 1/3 of
the
the
doctor assessed
disability
40% functional disability.
No. ಬಲಗಾಲಿನ ಚಲನೆಯಲ್ಲಿ ಶೇಕಡ 40%. 40% of the right, the lower limb.
What was his age? 26 years.
26 years.
According to the petition, it was 28 years.
So we have taken the income as 14,000.
40,000.
Added 40% towards future prospects. So the enhancement will be, and the loss of income, the enhancement towards the loss of future under the head loss of future earnings will be 1,48,512. So loss of income during laid up period is enhanced by 28,000. So total entitled enhancement will be 1,76,512.
That's right, my lord. As far as the whole body disability is concerned, that is 13% only.
13% only.
The
We have not
13% only.
increased. We
If
have
it is-
not
Now,
increased.
since it is less than 20% of the whole body, future prospects may not be
No,
attractive.
Mr. Counsel. Third, Sri Vijay Kumar T, Land Counsel for the Appellate, as well as Sri B.A. Ramakrishna, Land Counsel for Respondent number 1 Insurance Company. Next. The claimant is before this court seeking enhancement of compensation and disputing the findings given by the Motor Accidents Claims Tribunal, Srirangapatna, in the orders rendered in MBC 609 of 2019, dated 27/10/2020. On the ground that he sustained grievous injuries in a road traffic accident and became permanently disabled, the appellant filed a petition claiming compensation of rupees 21,20,000 in total. Full stop. The tribunal, through the impugned order, awarded a sum of rupees
47,000.
5,47,002 rupees as compensation, attributing contributory negligence to the extent of 30% upon the appellant. So in this 30% has to be deducted.
Hand recover order has been made, my lord.
Huh?
Hand recover order has been made. For the rest of 30% only.
So, 30% of this has to be deducted. Okay.
It may be retained.
How can we retain? Again, we have to, how can we retain?
That is the fixed on the respondent number 2, my lord. Respondent number 2.
Yes, this is a pay and recovery order. Already complied with the award.
In para 18, page number 17, my lord.
Contributory negligence of the petitioner 30%. Deducting 30% of the amount towards contributory negligence of the petitioner.
My lordship, fifth line from bottom, my lordship, page number 17.
Page number 17, from bottom second line.
It is necessary to direct the respondent number 2
Hmm.
pay such compensation amount first to the petitioner by deducting 30% of the amount towards contributory negligence of petitioner,
Yes.
and then to recover the same from owner.
What does it mean? You pay 70% and recover that 70% from the owner.
Yes.
Yes. What did you write?
Means on the basis of allowable.
What did you? Hmm, hmm, hmm. Appellant. Full
Yes,
stop.
it's compulsion. Placement.
The only grounds that were urged and argued by Sri Vijay Kumar T, land counsel for the appellant, are in respect of the amount awarded under the head loss of future earnings and the amount awarded under the head loss of income during laid-up period. Full stop. Land counsel states that the appellant sustained grievous injuries due to the accident and took treatment as inpatient for 20 days and thereafter as outpatient for more than 10 times. Full stop. Though the doctor, that is PW2, assessed the disability
%40.
40% of the limb.
as 40%, the tribunal took the disability as 13% and awarded a meager sum as compensation. Full stop. Land counsel also states that the tribunal awarded a sum of rupees 28,000 only under the head loss of earnings during laid-up period, and indeed the appellant could not attend his normal pursuits for more than a year. Full stop. Land counsel thereby seeks for enhancement of compensation. Full stop. Next, the submission that is made by Sri B.A. Ramakrishna, land counsel for respondent number 1, on the other hand, is that the tribunal, taking into consideration the totality of evidence, has awarded a just sum as compensation, and therefore the award needs no interference. Full stop. A perusal of record reveals that the tribunal has awarded a total sum of rupees 7,81,432 as compensation, divided under following heads, and thereafter ordered deduction of rupees 2,34,430 towards the contributory negligence of 30% on part of the appellant. The tribunal assessed the whole body disability as 13%, which needs no interference. Full stop. The age of the petitioner is taken as 26 years, which also needs no interference. Full stop. The tribunal, for the reasons best known, has not added future prospects. Full stop. 40% of the actual earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. This court does not find any grounds to interfere with the notional income that is taken by the tribunal at the rate of 14,000 per month. Full stop. Also, the appropriate multiplier which is applied is 17, which requires no interference. Full stop. Thus, the compensation which the appellant is entitled to under the head loss of future earnings due to permanent physical disability is as under. Notional monthly income 14,000, annual income 1,68,000, add 40% towards future prospects 2,35,200, apply appropriate multiplier 17 39,98,400. 13% being permanent physical disability. Loss of earnings is, loss of future earnings is 5,19,792. Next, the tribunal awarded a sum of rupees 3,71,280 under the head loss of future earnings. Thus, the enhancement will be 1,48,512 within brackets 5,19,792 minus 3,71,280. Next paragraph. Coming to loss of earnings during the laid up period, the tribunal has awarded a sum of rupees 28,000 only. It is borne by record that the appellant sustained fracture of left tibia and through a surgery, implants were fixed. It is also brought on record that the appellant took treatment at Nimhans Hospital for the head injury sustained by him. Thus, having there is no denial of the fact that the appellant took treatment as inpatient for about 20 days and it also took treatment as outpatient for 6 to 8 times. Therefore, this court is of the view that the appellant would not have attended his normal pursuits at least for a period of 4 months. Thus, the loss of earnings during laid up period comes to rupees 56,000 within brackets 14,000 into 4. The tribunal, as earlier stated, has awarded a sum of rupees 28,000 only under the head loss of income during treatment period. Thus, the enhancement will be 28,000 within brackets 56,000 minus 28,000. Next paragraph. Thus, in the light of the foregoing discussion, the enhancement, the amount which the appellant is entitled to in addition to the sum awarded by the tribunal is 1,76,512 within brackets 1,48,512 plus 28,000. Next, out of the enhanced sum, in the light of the contributory negligence on part of the appellant being 30%, the respondents are liable to pay a sum of rupees 1,76,512 only in addition to the sum that is awarded by the tribunal. 1,76,512 only. There you within brackets you write 70% of amount 1,76,500. You write as you don't write 1,76,500. The appellant, the respondents 1 and 2 are liable to pay a sum of rupees. You remove that. I'll tell again. In the light of the contributory negligence on part of the appellant to the extent of 30%, the appellants are liable to pay a sum of rupees 1,23,000.
Respondent number 2.
23,000.
Respondent number 1 year.
558.4 rounded to 1,23,560 within brackets 70% of 1,76,512 brackets close to the appellant. Thus, the appeal is disposed of with the following. the appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal Srirangapatna through orders in MVC 609 of 2019 as against the respondents 1 and 2 is enhanced by 1,23,560. Full stop.
Order of pay and recovery.
Respondent number
2
1 is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop. Respondent number 1 is given liberty to recover the same from respondent number 2 by initiating appropriate proceedings. Full stop. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, on such deposit, the appellant is permitted to withdraw the entire amount. Yes.
Placement.